We will get the. Yeah.
All rise, circle forth, Judge David Williams preside.
Please bow your head for a moment of silence, please. Thank you. Everybody proceed. Commonwealth versus Angela Allen. Are you Angela Allen? You have to speak up.
Yes, sir.
Okay. What's your year of birth?
1970.
Last four digits of your social security number?
5659.
What?
5659.
Okay, we're here on a pretrial conference. What's the Commonwealth have?
We have a pretrial diversion plea.
A motion has been tendered, ma'am, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
You are?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You're the same person that we just identified in 25 CR 0020?
Yes, sir.
Okay,
Yes, sir.
okay. I mean, are you aware of what's going on here today?
Yes, sir.
Have you talked to this lady?
I have, yes.
You can just say yes or no. You don't have to say sir every time, okay? Is your judgment impaired today in any way?
No.
Okay. Have you discussed these charges with your attorney?
Yes.
Are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you and you feel like you're fully informed about your
Yeah.
case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights on the Kentucky and United States Constitution. I'm going to go down through those rights, and at the end, I'm going to ask you if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to trial, speedy trial in a jury. You have the right to be represented by counsel at all stages of proceeding. You have a right to confront and cross-examine witnesses called to testify against you. You have the right to produce evidence and call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. Do you understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence allowed in the law. If I do not accept the recommendation and decide to impose harsher punishment, you have the right to withdraw your plea of guilty and proceed to trial. Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No.
Have you had any felony in the last 10 years?
No.
You understand that if you successfully complete the pretrial diversion, it will be dismissed, pretrial diverted, and you can have your record expunged. You understand that?
Yes.
What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pretrial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served and be released from incarceration upon the plea. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style case disposed of in accordance with laws, the Commonwealth, and the holding agency.
Is that your understanding?
Yes.
What are the court costs involved here?
$160.
Okay, if I accept this, you will need to pay $30 a month upon your release, okay? Now, you understand if you do not successfully complete the diversion program and you're brought back in front of me and I revoke your pretrial diversion, you'll be a convicted felon that can be used against you in the future. Do you understand that?
Yes.
Are you pleading guilty because you did commit the acts that are charged in the indictment?
Yes.
Are you doing so of your own free will? Knowing your constitutional rights explains to your desire to proceed and complete without the court to fix your punishment. Is that your signature on the document?
Yes.
I accept the pretrial diversion. And we'll sign it today. You'll need to. This calls for her immediate release. Is that correct?
Yes.
Okay, you'll need to make arrangements to meet with the probation parole officer over there. I'll sign it today. And do you have things at the jail up there? Or do you have people here to pick you up?
I have to just go get my clothes.
Okay, well, they'll transport you back up there. And then you'll have somebody available to pick you up there, okay?
Thank you.
John Carter, you want me to do the women first? Are you transporting them separately?
Well, now we've got them all, we've got
Okay.
everybody again.
Okay, let me give John Carter.
Judge, he's in Hardin County.
Swear,
He's in Hardin County.
Hardin.
are we have them scheduled by Zoom or not?
I'll send them the link. We have someone else on page, so.
Okay,
They should
we'll
be
come
on.
back to him. Hardin, Allen County, ACRG, is that Allen County Correctional Regional Jail is, you turn on?
That's correct.
That's Adair County.
It's Adair County, okay, well, forget that then. We'll come back to Adair County. Alfred Cresilius,
He had to have surgery, emergency involved.
yeah,
It's
okay,
still in the hospital.
Yeah, he's still in hospital.
so we pass over here.
We can do this.
Jonathan Gilbert. Cromwell versus Jonathan Gilbert, 25 CR 0039. Are you Jonathan Gilbert?
Yes, sir.
Good morning.
Good morning.
You born in 1985.
Yes, sir.
The last four digits of your social security number is 0078.
Yes, sir.
We're here for a pre-trial conference. What's the Commonwealth have to say?
Your Honor, he's been indicted in federal court on the same, pretty much the same case, and we have to let them go first on that case. So I would ask this be either continued generally or maybe 6 months down the road,
What's the charge here?
trafficking and with weapons involved.
The feds have a hold on him?
Well, he has been, my understanding, he's gonna be indicted in federal court, sir.
Well, I mean, I'm not gonna let him loose still then.
No, I just asked it be continued.
Continued without a bond here.
Whenever he wants to review it, if they've not taken any action, I'll be glad to take it up in the state.
That works for us, Your Honor.
Pardon?
I said, yes, that works for us.
Okay. Okay, thank you. Stacy Harold.
That's a plea, so.
Commonwealth versus Stacy Harold, 25 CR 00030. Are you Stacy Harold?
Yes,
You're here for a pretrial conference. You were born in 1990.
yes,
Last four digits, social security number 1485.
yes.
What does the Commonwealth have to
We have a
say?
felony plea, Your Honor.
What's going on? What's going on over here?
Sorry, Your Honor, we're just stepping back just because of that.
Is, you have multiple prisoners back there?
Yeah.
I don't know whether it's gonna be safe if you go back there right now because
Bill,
well, there's an observation room back here. Are you familiar with the observation room?
Yeah.
It will allow you to have privacy with your client and outside the presence of other. I just don't think you can have a private meeting back here with your client without other people being in earshot. That's the reason I'm trying to intervene.
Okay.
Well, one of the bailiffs, you come up here, will you take these counsel back here and show them the cell and see if that's sufficient? And if not, we'll make other arrangements for you, okay?
Thank you, Judge. Sorry about the disturbance.
You're Stacy Harold.
Yes,
You were born in 1990.
yes,
The last four digits of social security number 1485.
yes.
We're here on 25 CR 0030 for a pretrial. What's the Commonwealth have to say?
Yes, we have a felony plea.
Okay. A motion has been tendered that says you wish to enter a plea today. Is that correct?
Yes,
Are you currently under the influence of drugs or alcohol?
no,
Is this plea freely and voluntarily given?
Yes.
Are you the person that we just identified in 25 CR 0031?
Yes.
Okay. Is your judgment impaired today in any way?
No.
Have you discussed the charges with your attorney, and are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you, and you believe you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. I'm going to go over those rights with you. At the end, I'm going to ask if you understand them. If you don't, you can step away and talk to your lawyer. Okay?
Okay.
You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. Understand that by entering a guilty plea, that you give up all those rights.
Yes.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence prior to the law. I don't have to accept your recommendation. Prior to accepting recommendation, I'll await a pre-sentence investigation report. Be done until probation and parole. In the event that I do not accept the recommendation after reviewing that report and decide to impose a harsher penalty, you have the right to withdraw your plea and
Yes.
proceed to trial. What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to unlawful transaction with a minor, second degree, the defendant shall receive a sentence of 5 years. Upon a plea of guilty to complicity to tampering with physical evidence, the defendant shall receive a sentence for 5 years. The 2 5-year sentences shall run concurrently for a total of 5 years, serve 90 days in jail, and then serve 90 days on home incarceration with the balance probated for 5 years, supervised. The home incarceration shall be hooked up prior to the defendant being released from incarceration. The defendant shall receive credit for time served. The defendant shall forfeit the Taurus Spectrum 380 handgun bearing serial number 1F033895 with magazine and 6 rounds to the Commonwealth, and it to be disposed of in accordance with the holding agency and the laws of the Commonwealth. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding of the recommendation?
Yes.
Tell me about the gun.
My understanding is Ms. Harrell was on probation out of Iron County on fraudulent benefits, so supervised, she wasn't supposed to have them. So it doesn't matter, she really messed up, in order to evade the detention of the she sent a child placed under a trailer on the back. So that's the issue. My understanding, she was in compliance on probation.
It was in a lockbox.
It was in a lockbox, kind of a safe, and then that safe.
Nobody can get in it.
Hey, she pleaded guilty to the gun?
She was only charged with unlawful providing handgun to juvenile,
And transaction of mine. Tampering with evidence.
and she is pleading guilty to the
Was she a
unlawful.
convicted felon when she had the
Now
gun?
she's on the verdict. I could have indicted on that, but I just went with the charges the officer had in the case. Because people don't realize, if you're in possession of a gun, even on a pretrial diversion, the law states you can be indicted on possession of a firearm by a convicted felon.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes.
Doing so of your own free will,
Yes.
knowing your constitutional rights have explained to you, is it still your desire to give up those rights, enter pleading guilty to charges and allow the court to fix your punishment?
Yes.
You understand that after entering a guilty plea, any convictions could be enhanced under the persistent felony offender law.
Yes.
Is that your signature?
Yes.
I order a pre-sentence investigation to be done, and scheduling will be scheduled, sentencing will be scheduled on July 31st. I'm still very apprehensive about the gun. I'm just telling you. And so we'll just take a look at that when it comes, okay? Thank you very much.
Thank
Gene Parrish. Commonwealth versus Gene Parrish. Are you Gene Parrish?
Yes, sir.
Good morning.
Good morning.
This is 25 CR 0011, Commonwealth of Kentucky versus Gene Parrish. Mr. Parrish, were you born in 1989?
Yes, sir.
Last four digits, social security number 9523.
Yes, sir.
You're here on a pre-trial conference, what the Commonwealth have to say.
Felony plea.
A motion's been tendered that says you wish to enter a felony plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No.
This is plea freely and voluntarily given.
Yes.
Are you the same person we just identified in 25 CR 0001?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Is your judgment impaired today in any way?
No.
Have you viewed the evidence the Commonwealth has against you, feel like you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I mean, you have to know that you understand those rights. I'm gonna go over them. But anytime you don't understand what's going on, you can step away and talk to your attorney. You have a right not to testify against yourself. No one can make you say anything, right to speak, trial by jury, the right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. The right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. You understand
Yes, sir.
that by entering a guilty plea today, you give up the charge. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply the range of sentence allowed by law. I don't have to accept the recommendation. Prior to accepting the recommendation, I will await a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree, third offense, methamphetamine, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall be referred to the social service clinician and shall follow any and all recommendations of the clinician. The defendant shall receive credit for time served. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
You know, are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You plead guilty of your own free will because you are guilty and for no other reason.
Yes, sir.
Nor your constitutional rights to explain to us it's still your desire to proceed with your plea and allow the court to fix your punishment within the range permitted by law.
Yes, sir.
You understand that after entering this plea, you will be a convicted felon, and any future convictions could be enhanced as far as the range of penalty under persistent felony offender law. Do you understand that?
Yes, sir.
Is that your signature on the offer?
Yep.
Yeah, I'll accept the agreement, order a pre-sentence investigation report to be under probation and parole with schedule of sentencing for July 31st, okay? Dorothy Poland. Are you Dorothy Poland?
Yes, sir.
Good morning.
Morning.
You're here on 23 CR 0083. Are you born in 1985?
Yes, sir.
Last four digits, social security number 6826.
Yes, sir.
What does the Commonwealth have on Miss Poland?
It's a mission like that.
Missing. A motion's been tendered, says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
It's pretty freely and voluntarily given. Are you the same person that we just identified in 23 CR 0083?
Yes.
Have you discussed this matter with your attorney and are you satisfied with his advice?
Yes.
Have you viewed the evidence Commonwealth has against you, feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I accept the plea, I need to know you understand those rights. I'm gonna go over them at the end, ask you again. Okay. You have a right not to testify against yourself. No one can make you say anything. Right to speak, trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to fix evidence, right to call witnesses in favor. Right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand it by entering guilty plea today, you give up all those rights. Understand that?
Yes.
You know, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I do not have to accept the recommendation. Prior to accepting the recommendation, I'll order a pre-sentence investigation report done by probation and parole. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. What is the Commonwealth's recommendation of Court Anderson?
Upon a plea of guilty to possession of marijuana, the defendant shall receive a sentence of 12 months, probated for 2 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served and be released from incarceration upon entry of this plea. The defendant shall pay a fine in the amount of $200 plus cost. The defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that your understanding?
Your Honor, I believe it's supposed to be unsupervised. We have an amended agreement
That
here.
is correct.
Okay.
Is that your understanding?
1 year, 2 years. Yes.
And what would be the court costs?
Fine includes $425.
And we'll address that at sentencing, okay? Well, we have to, that's correct. So you need some time to pay the 425?
I can't today, but I mean, I will make payments, yes,
Well,
yes,
so the answer is yes, you do need some
Yes.
time. Can you pay $30 a month?
yes, sir.
Okay, first payment would be due $30, 30 days from today. And you're entering a plea here to the amended charges by your own free will, correct?
Yes.
Nor you, because this is not enhanceable. I told you before, I read down through the normal felony situation, this is not enhanceable. Knowing your constitutional rights is still your desire to give up those rights, enter a plea to guilty and allow the court to fix your punishment. Is that your signature on the document offered?
Yes, sir.
I accept the agreement. You'll still need to meet with the probation parole officer over there. At some juncture to get some information, even though it's a misdemeanor. Is that true?
It's a misdemeanor, Your Honor. We don't really.
You don't need to meet with her, okay. So I'll sign an order. This order will be entered today and then we'll send the document up to jail. They'll transport you there. Do you have somebody to pick you up up there?
Yes, sir.
You know, it'll take a little while to get everybody else processed, but we'll go ahead and try to send the order to the jail as soon as possible, okay?
Thank you.
Thank you very much. Johnny Riley. Oh, what do you got? He brought this. Yes. Oh. Cromwell versus Johnny Riley, 25 CR 0023. Are you Johnny Riley?
Yes, sir.
Good morning, Mr. Riley. Good morning. Were you born in 1989, sir?
Yes, sir.
Last 4 digits, social security number 9320.
Yes, sir.
Okay, what does the Commonwealth have to say?
We have a pre-trial diversion plan.
And 23 CR 0023, a pretrial diversion. Motion has been tendered, says that you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
Sir.
Is this plea freely and voluntarily given?
Yes, sir.
You previously stated your full name, year of birth, and 4 digits of social security. Is that correct?
Yes, sir.
You are that same person.
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you reviewed the evidence Commonwealth has against you, and do you believe you've been fully informed about this case?
Yes, sir.
Do you understand that you do not have to enter a guilty plea? You have certain rights under Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
Okay? I'm gonna go over them, and at the end, I'm gonna ask you if you understand. If there's anything you don't understand, you can step away and ask your attorney, okay? You have a right not to testify against yourself. No one can make you say anything. Your right to speak, trial, but your right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to give us evidence. Right to call witnesses in your favor. Right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you are guilty of the charge. You understand that by any guilty plea, you give up those rights.
Sir.
And I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have any felony in the past 10 years?
No, sir.
Currently on probation or pretrial diversion?
No, sir.
You understand if you complete the diversion successfully, the charges will be dismissed, pretrial diverted. You understand if you do not successfully complete the diversion, you will be brought back before the court, and the court will schedule a sentencing hearing. You'll be a convicted felon. That can be used against you in the future. You understand that?
Yes, sir.
Now, you also, if you successfully complete the program, you can have a pretrial diversion, you can have an expungement. You understand that?
Yes, sir.
What is the Commonwealth's recommendation?
Yes, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence of the above style cases disposed of in accordance with laws of the Commonwealth and the holding agency.
Is that your understanding of the Commonwealth's recommendation?
Yes, sir.
Are you pleading guilty because you did commit the act charged in the indictment?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Knowing your constitutional rights to explain to you still your desire to give up the rights and the guilty plea and allow the court to fix your punishment within the range of the law.
Yes, sir.
Is that your signature on the document there?
Yes,
I'll
sir.
accept the agreement and sign the diversion program. Now, was he to be released today too, Mr. Stockton?
Yes, Your Honor.
Yeah, I'll sign the document and process it, then we'll send the order back to the jail. Do you have somebody, prepared to pick you up there today?
I can probably call somebody.
Well, do you have stuff up there at the jail?
Yeah.
So, I'll send the order up there, but you make some provision. Court cost is $190. You need some time to pay that.
I got that ability, so yeah.
Well, I'll let you pay $30 a month. Okay? First payment, 30 days from today. If you'll allow him to use a phone or something on the way back, try to arrange somebody to get you, because they'll put you out on the street up there. It's
Yeah.
a long walk back on a hot day,
Yeah,
man.
it's pretty hard.
Yeah. Hope things turn around for you.
Trust me, they will.
Okay. I do trust you. I wouldn't be doing this. Okay. I trust the dealer, but I always cut the cards.
Yeah, yeah.
Okay, see, like Elizabeth Scott. Commonwealth versus Elizabeth Scott. 25 CR 0032. You are Elizabeth Scott. Yeah, you were born in 1992.
Yes.
And last 4 digits, social security 5440. What's
Yes.
Commonwealth have to say?
Your Honor, she was terminated from drug court this morning, so if we can have a negotiation day on this case, maybe we'll work out an arrangement on all cases.
What is the negotiation date?
July the 25th at 9 a.m.
Either July 25th at 9 a.m. and then the next scheduled court day, if you reach an agreement, is July 31st, okay? Tiffany Stilts. Commonwealth versus Tiffany Stilts, 25 CR 0029. Are you Tiffany Stilts?
Sir.
You born in 1988?
Sir.
Last 4 digits of social security number 4351. You're on a pretrial conference. What's the Commonwealth have to say?
We've got this in your plea.
Okay. A motion's been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0029?
Yes, sir.
Have you discussed this matter with your attorney? Are you satisfied with his advice? Have you viewed the evidence the Commonwealth has against you?
Yes, sir.
Are you reading something there or what are you doing?
Yeah.
here? Well, I want you to make contact with me here, okay?
Yes, sir.
So I understand that you know. You believe you've been fully informed about your case?
Mhm.
You have certain rights under the Kentucky and United States Constitution. Before I accept your plea, I need to know that you understand those rights. You have the right not to testify against yourself. No one can make you say anything, right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, or right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, and right to apply to the Commonwealth, prove on a reasonable doubt that your guilty charge against you. You understand that, but in a guilty plea, that you give up all those rights. You understand that? I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law, or may reject the recommendation. Prior to accepting your recommendation, I will wait the pre-sentence investigation. Well, this is a misdemeanor, so there won't be a pre-sentence investigation. In the event that I do not accept the Commonwealth's recommendation, decide to impose a harsher sentence, you have the right to withdraw your plea guilty, proceed to trial. Ms. Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to fleeing or evading police, third degree, the defendant shall receive a sentence of 12 months probated for 2 years supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served and be released from incarceration on July the 7th of 2025.
Is that your understanding?
And the defendant shall have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth.
Is that your understanding of the recommendation?
Sir.
Okay. Are you entering this amended plea because you are guilty of the acts charged in the indictment as amended?
Yes.
Okay. Knowing your constitutional rights, explain to you it's still your desire to give up those rights, enter a plea of guilty and allow the court to fix your punishment as permitted by law. Knowing your constitutional rights as I've explained it to you, is it still your desire to give up those rights by entering a plea of guilty to the charges and allow the court to fix your punishment and arrange permitted by law?
Sir.
You understand that, is that your signature on the document there?
Sir.
Okay, I'll accept that what's court costs? What, how much?
$220.
Need some time to pay that? Okay, I'll let you pay it $30 a month and I won't make the first payment due to 30 days from today. Well, I'm 30 days from July 7th. You're getting out on July, that's what you said, July 7th, she's getting out. First payment will do 30 days from July 7th, okay? Thank you very much. Cody Stinson. Caldwell versus Cody Stinson. Are you Cody Stinson?
Yes, Your Honor.
Hey, good morning.
What?
Were you born in 2004?
Yes, Your Honor.
Last four digits, social security number 8596.
Yes, Your Honor.
You're on 24 CR 0044 and 24 CR 0085. What does the Commonwealth have to say?
Felony for you.
Okay, a motion has been tendered, Mr. Stinson, that says you wish to enter a plea today. Is that correct?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person that we just identified in 24 CR 0044 and 25 CR 0085?
Yes, Your Honor.
Is your judgment impaired today in any way?
Oh, Your Honor.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes.
Have you reviewed the evidence Commonwealth has against you? You feel like you're fully informed about your case?
Yes, Your Honor.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution before I accept the plea. I need to know that you understand those rights. We'll go over the rights. If you have any questions about me, step away and ask your attorney. You have a right not to testify against yourself. No one can make the same. Any right to speak trial, but jury right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Your right to produce evidence. The right to call witnesses in your favor. The right to appeal this matter at higher court if you lose. The right to file your Commonwealth to prove on a reasonable doubt that you are guilty of charges against you. Understand that by entering a guilty plea today, you give up those rights. You understand that?
Yes, Your Honor.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. And this is a diversion offer that you.
No, this is felony plea.
Do a felony plea, great. Now, prior to accepting any recommendation, I will wait the pre-sentence investigation report to be done by probation pro. In the event that you do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and go to trial. What is the Commonwealth's recommendation?
Your Honor, 24 CR 44, he will plead guilty to rape, second degree, receive a sentence of 10 years to serve. And case number 24 CR 85, he will plead guilty to rape, second degree, 3 counts, 10 years on each charge, run concurrently for a total of 10 years. Both sentences will run concurrently for 10 years. The Commonwealth will oppose probation He'll have no contact with the victims. All evidence will be destroyed in accordance with the law.
Is that your understanding of the recommendation?
Yes, Your Honor.
Are you pleading guilty because you committed the acts charged in the indictment as amended?
Yes, Your Honor.
Doing so of your own free will.
Yes, Your Honor.
Know your constitutional rights explained to you is it still your desire to give up those rights, enter a guilty plea, and allow the court to fix the punishment and arrange permitted by law.
Yes, Your Honor.
You understand that after any guilty plea, any future convictions can be enhanced under persistent felony offender law.
Yes, Your Honor.
Okay, is that your signature?
Yes, Your Honor.
Now, I'll accept the plea and I order PSI, but there'll have to be a sexual offender evaluation too, so it'll usually take a little longer. I will schedule sentencing for August 28th.
Thank you.
I'll call a case of Thomas O'Donnell. What did you say about it?
The insurance.
Well, pass over his case. Did y'all hear that about his location?
No, Your Honor.
See, he's in Eastern State Hospital. Have you been in contact with him?
Not in 3 or 4 days. Since Friday last week.
Let's see, we have, yeah, that.
Okay. Well, let's just continue it to the, July 31st. Now, when you took him up there, y'all have to have a guard with him up there, right?
No,
Okay. So when he gets out, then they'll
they transport me back, yeah,
back to Dare County?
yeah.
He was out of custody.
Okay. Thought I remembered something about that. What are we gonna do about that? So. If he's out, if they let him out of Eastern State, then he continues on the same bond and just go ahead and schedule it for the 31st. Did he exhibit any dangerous symptoms or anything? He wasn't,
Not really, no, he did not those, he did.
okay.
Judge. I'm sorry. I'll show you this. It's, while he was at Eastern State, they sent this out to dispatch.
He made allegations. I thought there was some, evidently, and I don't know if this is true or not, but Eastern State contacted authorities here that said that he had made some threats against an officer here. That he was going to take an action or kill an officer.
Well, I would ask that his bond be adjusted to take that into account. If we have to schedule a bond hearing, we can. That way, if he's released from Eastern State, we can have a bond hearing.
15,000 sureties with.
Okay, well, I'm gonna put a $50,000 cash bond on it. And to notify them if they get time to release, to contact the sheriff's department here to transport him to their
We'll
county.
have to issue a warrant, because there's nothing taking into custody of this one.
Bond, let's do a bond violation. Do a bond violation on him, taking him and holding him without bond. Bond violation, okay. Timothy Boggs. Commonwealth versus Timothy Boggs, 25 CR 0021. Are you Timothy Boggs?
Yes, sir.
Were you born in 1999?
Yes.
Last 4 digits of your social security number are 4290.
Yes.
You're on the pretrial conference.
Your Honor, we weren't able to come to a resolution.
What's the charge, Mr. Stockton? You want to come up or somebody tell me what's
It's
going on?
trafficking control first. It's, yeah, 4.8 grams of methamphetamine possession.
What did you offer?
I think I offered a split sentence, some jail time.
On possession?
No, I think it's trafficking 5 to 180 days was offered, and I never got a counter offer, so
How much, what was the quantity?
5 grams.
If we could do one more negotiation on this, we might be able to come to a resolution.
I'm gonna go ahead and set him a trial. If he wants a trial, we'll get one, see what the jury will do on it. Let's see, is Commonwealth versus Thompson gonna go on the sixth, seventh, and eighth? It's Clinton County case.
It's on, I've got it set for the 8th.
I got it set for the seventh today.
Well, I think we've decided it was the 8th. We need to do an order, we will, but it was,
No, I
we
understand.
bandied it kind of back and forth in court.
I'm just asking.
Yeah, it's the 8th, I believe. As of right now, it's going.
I'd like to do it sometime in July. Yeah, the trial set on July the eighth. That Thompson that we just talked about, who will be trying that case?
I will be.
Yeah, who will be trying to hit this case here?
Probably not me.
Yeah,
I don't know.
yeah, so
I don't know who-
what I'm saying is
Anderson or
we
Mr.
can
Anderson.
we can schedule.
And I've got to
this
determine who's gonna handle this, O'Donnell thing too. I may do that or I may get somebody
Yeah,
else.
well, July the 9th is a Wednesday. But I'm tied up for the next 2 weeks after that. What about on July the seventh, the Monday after July 4th weekend, so I don't know what people be like wanting to come to jury that day or not. So
You say, is the 9th available?
the 9th is available and the 11th is available.
Yeah, the 9th would be all right, the Commonwealth, if it's all right.
It's a Wednesday, the 11th would be better on Friday for the have access to the courtroom. Are you available on the 11th?
I am available.
Okay, let's do it on the 11th. Christopher Kettert. Is that how you pronounce your last name, Kettert? Kettert, okay. This is 25 CR 0028. Sir, were you born in 1992?
Yes, Your
Last four digits, social security number 6041.
Yes,
Here for a pretrial conference. What's the
We're
comment?
still waiting on the lab report. Can we have one more negotiation day, you know?
Negotiation day on July. Is that 25th?
25th.
25th?
Yes, Your Honor.
25th, and the next court date is July 31st. You're under the same bond, okay? Michael Diamond. Commonwealth versus Michael Diamond, 25 CR 0027. Mr. Diamond, you born in 1953.
Yes.
Last four digits, social security number 1726.
Yes.
We're here for a pretrial conference. What does the Commonwealth have to say?
Your Honor, when we had tried to have the Thompson trial last week, that messed our coming negotiation day up, so we've not been able to have one. Can we have another one on this?
July 25th, for a negotiation day, and the next court day is July 31st. Now, I'm going to take a short pause here and do these, Casey County and in Grayson County that are scheduled at 10. And Hardin County that was scheduled at 10. And LaRue County that was scheduled at 10. And Simpson County that was scheduled at 10. So if everybody will just hold on here, let's see who's on the line. Grayson County, will you turn your camera on, please? Grayson County. Thank you. This is Grayson County and Commonwealth versus Mark Cruz, 24 CR 00014. Are you Mark Cruz?
Yes, sir.
Is your year of birth 1970?
No, 1960.
1960. Last four digits, social security number 3369.
Yes, sir.
You're on a probation revocation. You're represented by the Office of Public Advocacy. What does the Commonwealth have to say?
Your Honor, Mr. Cruz has a 3-year sentence on possession of controlled substance, first degree. We were here in March, I think, because he had violations in February where he would not produce and provide a sample. You heightened his supervision. He served a jail sentence and sanctions. We filed another motion for May because he wouldn't produce on May the 1st and May the 5th.
Yeah.
I mean, he has some medical issues he's dealing with, Your Honor.
And that may be, but the Commonwealth's not seen the first medical record. This has been ongoing since December. So if he's got medical issues, it'd be nice to share that information. I'm not fussing on Mr. Rutherford here.
I'll go ahead and fuss on him.
I'm fussing on Mr. Cruz for not providing probation.
What does the probation officer have to say?
Well, this is the problem. We may need to get another date. Mr. Campbell's here, but the person that supervises him is out of state this week. So we'd have to have another date.
What's he being held in Grayson County?
Well, he evidently, he violated up there. He may have tested positive in court. They entered an order to send him to long-term treatment. Grayson County has.
If the Commonwealth would be willing to consider long-term.
No, I'm not willing to do that. Commonwealth is willing. I won't even put him on the spot to say that because I'm tired of people not complying with testing requirements and blaming it on some alleged problem with medical things. He wouldn't be alive if he hadn't urinated sometime between now and the time we were here last time. So that's just it. So we will, what date do you want to schedule?
I guess we can do it. If you want to do it the next motion day, we'll have Mr. Taylor available.
Okay, let's on July the 31st. Grayson County, thank you very much. And I want a transportation order done on this gentleman to bring him here on July 31st.
I will, Your Honor.
Grayson County, thank you very much. You all are excused. Casey County, are you on the line? Casey County. Okay, they'll need to turn the microphone on there in Casey County. The microphone is not on, the little red thing that looked like an ancient microphone. Somebody needs to push the button. Will somebody at the Casey County Jail help Maggie Scott push the correct button?
I saw her a while ago.
There you go. Are you Maggie Scott?
Yes.
I don't think.
Can you hear me?
I don't think you'll need your phone. This is 24 CR 0050, 24 CR 0078. Were you born in 1984? Were you
Yes,
born
I
in
did-
1980? No, can you hear me? Can you hear me?
Born in 1984?
That's what I said. Can you hear me?
Yes, I'm sorry. I can't hear you unless I have the telephone thing.
Well, you can use the telephone thing if you want to. It's okay. The last three digits, social security number 3307.
Yes, sir.
You're here on a motion for shock probation. What do you have to say, Mr. Cross?
Your Honor, we filed this as soon as
You
we
need to
could.
speak up real loud.
We filed this as soon as we could for Maggie. We were familiar with her when she first came in last year. Had very little record, went off the rails with some drug issues. Had no prior record to be 40 years old, had very little prior involvement with the court system. You've got small kids, got good support. What we'd like to do is get her out, put her in a 28-day program at Women Finding Freedom, and then mandate she have at least 90 days thereafter, either with Women Finding Freedom or a follow-up facility. She's never been in a rehab.
What was her, what was her,
Behavior and how to live
what
in
was her
society.
plea on?
Your Honor, she had two different possession cases. She had one in Cumberland and one in Clinton. We transferred the one in Clinton over here. So she took 2.5 years on each case for a total of 5 years on possession. She was on probation. She continued to drive without a license, continued to use meth, so we put her in the specialty court program. She was terminated from the specialty court program because she continued to drive and continued to use meth. So she's never done either time what she's supposed to do. And I just think if the court does want to leave her after rehab, I would think a minimum of 180 days somewhere, based on her performance, or lack thereof.
I'm inclined to agree with Mr. Stockton. As I say, she's never been, and there are some things she has to learn. And her record is such that I don't think we need to give up on her.
I'm not giving up on her. But when I put somebody in specialty court and they continue to illegally drive a motor vehicle, I'm not gonna overlook that. I think she's had her opportunity. You know, one of the greatest fears I have is that we'll have somebody that continues to drive and continues to take drugs and runs over a school bus and kills about 30 people. It's not too much to ask somebody. I understand drug addiction and everything, but they don't have to get behind the wheel and take off. So I'm going to deny the motion for shock probation. Thank you very much. Okay, you're Casey County, you're excused. Hardin County. Hardin County.
Hello?
Yeah, Commonwealth versus Seth Staley, motion for shock probation. You are Seth Staley, born in 1977, last 4 digits, social security number 7119, is that correct?
Yes, sir.
Go ahead.
Your Honor, his underlying charge was really due to psychiatric issue, which he's now been treating since he's in jail. I think he would be better suited if he could get better treatment, some type of dual treatment
What does the
program.
Commonwealth have to say about this?
Your Honor, he has, evidently, he was just up for parole when he was flopped by the parole board. He's not eligible for parole, I don't think, again for another year. He had a 3-year sentence on trafficking. He was placed on probation. Then while he was on probation, they did a home visit and he had a bunch of guns in his house. He was revoked. He played 2 years on the possession of firearms. So he's got a total of 5 years in.
Yeah, I'm not gonna shock probate anybody that's got a firearm charge. This ain't gonna happen. So he'll be eligible for parole again if I take it down, okay?
Okay, thank you.
Thank you very much.
So, that's where John Carter is at, in Vaughn County office.
John, who?
Carter.
Hardin County, y'all have John Carter there also. I know he's not scheduled to come in, but we had him on the docket and we understand y'all have John Carter. Would it be possible for y'all to retrieve him for us?
Yes, sir. Let me put you on mute and I'll get him pulled shortly.
Thank you so much. Wait till that happens. LaRue County and Simpson County will be with y'all just next up.
When I talked to the jail, he is a state inmate in Florida, generally they revoked him, we were assigned him when he earned.
Could you, Chip, see she goes back.
Yeah, approach 3 feet. That is.
You're being broadcast. Yeah, I know.
Meter sometime, potato.
Well, this could take a few minutes. Let's go on and see if we can pick up LaRue County. We'll come back to Hart. LaRue County, are you on there? Commonwealth versus Dewey McCoy, 24 CR 0053. You are Dewey McCoy. Hardin County will be let's go ahead and back to Hardin County, finish that up. And LaRue, you can leave your camera on and everything. We'll be right back with, we're back in Hardin County, Commonwealth, Kentucky versus John Carter. Are you John Carter?
Yes, sir.
You're here on a pretrial conference in 25 CR 0037. Mr. Carter, were you born in 1991?
Yes, sir.
What is your social security number 7225? What does the Commonwealth have to say?
Negotiation day.
Pardon?
Negotiation day.
Here, I'm gonna set a negotiation day in your case here in Cumberland County, Mr. Carter, for July the 25th. And the next court day is July 31st. And let's do a transportation order for Mr. Carter. Mr. Carter up there. Is he a state inmate? Are you a state inmate now?
Yes, sir.
Well, that might be more difficult as far as the transportation order, but if not, you need to go up there and see.
I'll be able to see
Your
it.
attorney will be up to see you on this case, Mr. Harden, okay?
I think they have a transportation order. I'm supposed to be coming back to Adair County.
Okay, well, that'll be, so your attorney will be responsible for getting the transportation order for you and getting you here on negotiation day on the 25th and then the next court date on the 31st. Hardin County, thank you for the courtesy. Y'all will be excused. Now let's go back to LaRue County. Commonwealth versus Dewey McCoy. Mr. McCoy, were you born in 1982?
Yes,
Last 4 digits, social security number 4837.
yes.
This is a motion for shock probation in 24 CR 0053. What is it? What do you got to say?
Yes, Judge, we filed a motion for shock probation for Mr. McCoy. We haven't made it at immediate 30 days, but it is timely, understanding the gravity of the charge, but also understanding my client's willingness and request.
So he hasn't been in 30 days yet?
What's that?
What would you say?
It's been past the 30 days, but before the 180.
Okay.
But we didn't file it just immediately within 30 days.
Yeah. What does the Commonwealth have to say?
Commonwealth supposed, Your Honor, he got a 15-year sentence on this case for trafficking. He was over at Brandon Polson's residence, and that's the same Brandon Polson we just tried, that Mr. Henderson tried on the trafficking case. It got 10 years. And he was sitting on almost 6 ounces of methamphetamine, 5.85 ounces. And he has an extensive criminal history. If there's anybody that doesn't need to be shock probated, it's Mr. McCoy.
I would say that, yes, Mr. Polston would have had a trial and found convicted. There is some mitigating circumstances there. I mean, he had been charged with something else, and there was I think 24 CR 52, which was the case that had been that precipitated this arrest, was subsequently dismissed by the Commonwealth as part of plea negotiations. But I would say
Your client entered a plea.
Yeah, and that was part of the plea agreement. It was the criminal abuse. I agreed to dismiss it just as part of the plea. I thought Mr. McCoy got a pretty good deal on this at 15 years based on the amount of the drugs and all the charges he's had. He got a PFO. He could have been looking at a class A. Or
Judge,
class B.
we wouldn't be bringing this unless my client has made every overture to me that he is wanting to enter into special court. I think I don't know if he's ever made those
He's been in there
overtures
before. He's been in specialty court before.
Judge, obviously it's at your discretion, and we
I
understand.
know, and I hate to be put in this situation with Mr. McCoy. He used to do work at my office. I've known his family for a long time. I've known his brothers and sisters. His dad was one of my first clients. But there's just sometimes that you just can't do something. I just can't do it. And I really think he's got all the potential in the world. All of his father's children. I know his father had a severe drug problem his entire life. But his father was a brilliant person and brought into the world. His grandfather was brilliant. His great grandfather, I knew all of them. Mr. McCoy is still young enough, if he gets paroled, that he can make something out of himself. But I cannot allow people with that quantity. And especially after the co-defendant went in front of the jury, got a severe sentence, was lucky he didn't get any more than that. They maxed him out. So I'm gonna, with great sorrow, I'm gonna have to deny this motion for site probation. Mr. McCoy, I hope you do well and you use your time constructively. I guarantee you that they got no program or class there that you can't ace out and prepare yourself when you get out, okay? Good luck. Good luck to you.
Thank you.
Simpson County.
They're not on.
Simpson County, are you on there?
They are not on.
Okay, well, we'll make some effort. Somebody needs to call Simpson County if they can, see if we can get them on. They'll follow instructions. We'll go back to out of custody. Jennifer Farley. Morning. Commonwealth versus Jennifer Farley, 23 CR 00112. You are Jennifer Farley,
I am,
born in 1972. The last four digits of social security number 8599.
yes.
Here for pre-trial conference.
Mr. Cross's client, he provided me with some records a few minutes ago.
Can we find Mr. Cross? Is Mr. Cross back there somewhere?
It is.
I thought this only happened in Clinton.
Only have for Mr. Cross is. Nothing geographic location. That's. This is Jennifer Farley.
Yes, Your Honor.
Here for pre-trial conference. What's the
Yeah,
come with?
Mr. Cross has provided me some records. I just need to confirm those. We're real close to a resolution. If we just have one more motion day, we should have.
July 25th for negotiation day and July 31st, the next court appearance. Crystal Gerald's.
Thank you, Your Honor.
Mr. Jailer, do you have anybody else on the docket or are you just waiting to see if you get somebody?
Yeah, it's, wait.
Okay. Are you Crystal Gerald's?
Yes, sir.
You born in 1980?
Yes, sir.
Last four digits of your social security number are 1147.
Yes, sir.
You're here on 25 CR 0032, 34 rather, and 25 CR 0002 for pre-trial conference.
We pass this on this, yeah, we need to submit some different papers. Okay. We need to.
Pass in the docket. Paul Gross.
So if you don't care, it's somebody.
Right here. Just use it.
Who's representing the Commonwealth in this case here? Paul Gross. Paul Gross.
For sentencing.
That's coming.
I've been able to get in touch with Mr. Gross to go over that.
He had a stroke. So he's not mobile. Where'd you get this information?
You know, like, they're really gross.
Yeah. Is he the one that went to
He's the
Nashville?
one who was in the hospital.
Where is he now?
I'm not sure.
Okay, well, we need to find out where he is and he was transported to Nashville for medical problems. I apologize for mentioning the kind of medical problem he had. I should not have done that. But in any event, if you'll find out, find the sheriff's department to find out where he's located. If you can help Mr. Brown, jailer, and we'll schedule him for sentencing on July 31st. Okay. Hannah Holly. Commonwealth versus Hannah Holly, 25 CR 0038. Are you Hannah Holly?
Yes, sir.
You were born in 1997.
Yes, sir.
Last four digits, social security number 8595.
Yes, sir.
You're here for pretrial conference. What's the Commonwealth have to say?
Here's a diversion, please.
As you've heard, a motion has been made that says you wish to enter a guilty plea. Is that correct?
Yes, sir.
Are you currently under the influence? Make sure that there is a matron available before she goes in there. Send down, you calling a matron up? Okay. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 25 CR 0038?
Yes, sir.
Is your judgment impaired today? What? Have you discussed these charges with your attorney and are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence the Commonwealth has against you? You believe you've been fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution.
Yes, sir, I do.
We'll go over them and at the end, you're gonna tell me whether you understand for sure or not. Okay? Yeah, right. Not testify yourself. No one can make you say anything. Right to speak trial by jury, right to be represented by counsel at the jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, the right to call witnesses in your favor, the right to appeal this matter to higher court if you lose, and the right to require the Commonwealth to prove beyond reasonable doubt that the guilty charge against you. Understand that by entering guilty plea today, you give up all those rights. You understand that? Now you can say, yeah, I understand. I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept any recommendation. And either there that I do not accept Commonwealth's recommendation, decide to impose a harsher sentence, you have a right to withdraw your plea to sort of trial. Okay. Have you previously been diverted in the last 5 years?
Nothing.
You have any felonies in the past 10 years?
Absolutely.
Are you currently on probation?
No.
And you understand if you could complete the diversion agreement, that the charges will be dismissed pre-trial diversion, you can have your record expunged. You understand that?
Yes, sir.
You understand if you not complete diversion, probably be brought back before the court, you schedule a sentencing, you're gonna be a convicted felon, and that can be used against you in the future. You understand that?
Yes, sir.
Now, is there a KCPC thing here going on? Just got a note here.
No, I haven't done the KCPC.
Oh, there was.
There was a order for a outpatient competency.
I forgot about it. I think last time we were in court, he mentioned it, so we.
Yeah, well, from her reactions here today and picking up with the nuance of what's going on and everything, I think she's fine.
Yeah, we could get this to play.
You stipulate her competency, okay? Now, did you go over the Commonwealth's recommendation?
I can, Your Honor. Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years, pre-trial diverted for 5 years, supervised. The defendant shall be referred to the social service clinician and follow any and all recommendations of the clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours per week of community service until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in accordance with the laws of the Commonwealth and the holding agency.
Is that what you agreed to, young lady?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment?
Yes, sir.
You do so your own free will and after consulting your counsel.
Yes, sir.
Okay, knowing the constitutional rights are explained to you, still your desire to proceed with the guilty plea and allow the court to fix your punishment.
Yes.
Is that your signature on the document?
Yes, it is.
Okay, what's the court cost involved in this?
Purse is $220.
Do what?
$220.
Okay. You need some time to pay that?
Please.
I'll let you pay $30 a month, first payment 30 days from today, okay?
Yes, sir.
Yeah, we'll just send notice that competence. Will you create an order to send it to us? And just in the order say that your client agree, acknowledge an open court, the competency, and it won't be necessary to have evaluation, get it to me as soon as you can. We'll send the case. Thomas Hoff. $25 CR 0022. Is that how you say your last name, Mr. Hoff?
Okay.
This is 22 CR 0022. You born in 1974, sir?
Yes,
Last four digits, social security number 1620. What does the Commonwealth have to say about Mr. Hubbard's case?
I don't know, we made an offer, I don't know.
What's the charge?
It's a trafficking charge. He's a co-defendant, Mr. Boggs. We just set for trial. I think that if Mr. Rutherford's gonna represent both of them, there needs to be a waiver entered with both of them signed.
I'm gonna get conflict for Mr. Hub.
Okay, well, I'm gonna set a negotiation day. You hadn't had a negotiation day, with him.
No.
Negotiation day for the 25th of July. And the next court appearance is July 31st. And y'all have conflict counsel for him within 10 days.
I will.
So if you'll do an order to that effect, conflict counsel, that'll give you a couple of weeks to meet with your new lawyer and prepare for your negotiation days. Okay? So you have 2 dates to remember, the 25th of July, you'll be here at 9 a.m. and the 31st of July for your next court hearing. Okay? Ashley Howard. Ashley Howard. Are you Ashley Howard? This is 25 CR 0044. Were you born in 1987? Last four digits, social security number 1833. Here today for a purpose of arraignment. This matter was brought to the court by information. And it was 25 F 0033, and now the new information number is assigned to circuit court case of 25 CR 0044. You acknowledge the identity of your client, receive the information, waive formal reading and arraignment. You're going to enter a plea of guilty, is that correct?
Yes, sir.
And what does the Commonwealth have to say about this? Is this a diversion or what is it?
It is, Your Honor.
Okay, a motion's been tendered, ma'am, that says you wish to enter a plea today, is that correct? You have to speak up because that's a voice activated microphone. Until you speak up, we won't see you, okay? Are you currently under the influence of drugs or alcohol?
No.
Okay. Is this plea freely and voluntarily given?
Yes.
You're the same person that was just identified in 25 CR 0044.
Yes.
Is your judgment impaired today in any way?
No.
You discussed the charges with your attorney.
Yes.
Are you satisfied with his advice?
Yes.
Have you viewed the evidence the Commonwealth has against you, feel like you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. Before I can accept the plea, I need to know that you understand those rights. I'm going to go over the rights with you. And at the end, I'm going to ask if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial or jury. Right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Or right to call this witness in your favor. The right to appeal this matter to a higher court if you lose. The right to require the Commonwealth to prove it on a reasonable doubt that you're guilty charge against you. Understand that by entering a guilty plea today, you give up all those rights. You understand that?
Yeah.
I may consider the Commonwealth's recommendation or may apply in range of sentence provided by law. I don't have to accept the recommendation. In the event that I do not accept the recommendation, decide to impose a harsher sentence than you've agreed to, you can withdraw your plea and proceed to trial. I'm going to do some preliminary questions with you. Have you previously been diverted in the last 5 years?
No.
Any felonies in the past 10 years?
No.
Are you currently on probation or pretrial diversion?
No.
Okay, do you understand if you fully complete the diversion program, the case will be dismissed, pretrial diverted, and you have your record expunged? Do you understand that?
Yes.
You understand that if you do not successfully complete the diversion, you'll be brought back in front of me. I'll have a pre-sentence investigation report done and be sentenced, and that could be used against you as a convicted felon in the future. You understand that? Miss Anderson, Gordon Anderson, what is the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 2 years, pretrial diverted for 4 years, supervised. The defendant shall be assessed and follow any recommendations of the social service clinician. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours of community service per week until gainful employment is obtained. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner that's consistent with the laws of the Commonwealth and the holding agency.
Is that what you agreed to?
Yes.
Are you pleading guilty because you did commit the acts charged in the indictment,
Yes.
information indictment? Doing so your own free will?
Yes.
Know your constitutional rights to explain to still your desire to give up those rights, enter pleading guilty to the charges and allow the court to fix your punishment.
Yeah.
Set your signature on the document.
We don't have the document here. We've already turned it in.
Have her identify her. Okay,
Yes.
I'll accept. Thank you. I'll accept the plea agreement and sign it. The version, or what are the court costs, Bob?
$160.
Need some time to pay that,
How much?
$160. Pay it $30 a month, first payment due 30 days from today, okay? You'll need to meet with the probation and parole officer because it's supervised. He's standing right there behind you. Billy Huddleston. Commonwealth versus Billy Huddleston, 25 CR 0025. You are Billy Huddleston. Good morning. Were you born in 1962, sir?
Yes.
Last four digits, social security number 3418. What's the Commonwealth have to say?
Based on some information Mr. Rutherford gave me this morning, I'd ask for another negotiation day, Your Honor.
July the 25th at 9 a.m. here. And the next court date's July 31st. Both of them are conditions of your bond, Mr. Rutherford, okay? Barbara Johnson. Simpson, let's go back to Simpson County here. Thank you very much. Commonwealth versus Sherry Coate, is that how you say?
Cote.
Cote, Commonwealth versus Sherry Cote, 20 CR 0041, you are Sherry Cote.
Yes,
Born in 1976, the last four digits, social security number, 7839.
Yes.
Okay, what do you have to say as far as the motion for sharp protection?
I just would ask that she be given another chance at long-term rehabilitation.
Well, give me some reasons for it.
She's, I think spending time in jail this time has really been an eye-opening experience for her.
What did she plead?
She's got a 3-year on possession of a controlled substance and she we filed 4 motions to revoke because she was always out of pocket or not doing what she's supposed to. And she's up for parole in July, which is just a few weeks. I would like to pass it, see if she makes parole.
Yeah, it'd be better for her to make parole than it would be to come out on probation. It's less restrictive in a way. So I'm gonna go ahead and put this off until July the 31st. And we should know what the parole board does for you. If the parole board lets you out, that'll be the best thing that can happen to you. Okay? And then we'll bring it back up and take a look at it. You'll have time to talk to your attorney, give you more detail. If they do flop you, we'll take a look at you, okay?
Okay, thank you.
Simpson County, thank you for your effort. You may be released. Okay, now we go back to Barbara Johnson. Where is Barbara Johnson? Barbara Johnson, Commonwealth versus Barbara Johnson.
Your Honor, she's got a 3-year sentence. She's in the Warren County Specialty Court Program. I had Mr. Campbell call. She's got a pending new fleeing and evading in Allen County, and Warren County is seeing what happens on that case. She's not been terminated from the program. I'm willing to pass this motion until we see if she's able to stay in the drug court program.
Okay.
She got a fleeing and evading down there?
Yeah, from reading the citation, she kind of, I don't know that she was going that fast, but she evaded law enforcement until she get to her mother's house. And ultimately this is according to citation, ultimately she came back out and told the officer she was sorry that she just didn't want to get another driving unsuspended ticket. So if you want to have a hearing next month, we can get her here. I'm kind of waiting to see what the drug court program does with it.
Let's schedule her to be here, just so we can get eyes on her.
Yeah.
On July the 31st.
And I guess we can, probation pro can contact her and make sure she's present. I'll speak here.
I will email the drug court liaison or where to start down there and have them notify her here on July
And
31st.
if between now and then, y'all feel like that there's something I need to know about, you can contact me directly and I'll order a pickup on her, okay? Okay, thank you, yeah. Angel Kington. Angel Kington. 25 CR 0019. Are you Angel Kington? Good morning. Were you born in 1996? Last four digits, social security at 5901. Okay, what's the Commonwealth having this case?
Your Honor, we had done paperwork previously, but we're gonna have to change it to a felony plea, so can we just put her on for a plea next month and redo the paperwork?
Well, she wasn't eligible for pretrial diversion.
No, we just found that out,
Why wasn't she eligible?
previous felony,
What kind?
Clay County.
Salina?
Yeah.
Yeah. Okay, will you be back here on, you going for the negotiation day?
Yes, so that way I can get the records and make sure we're doing.
July the 25th, you'll be here at 9 AM for negotiation, and July the 31st is your next court date, both of them conditioned to your bonds. What's she charged with this time?
Possession.
What's the quantity?
I don't know, depending on what her record is, I'll see what needs to be done.
Okay. Okay, well, we'll see you back here on those two dates, July 25th and July 31st, okay? Okay, thank you. Danny Pippin. Commonwealth versus Danny Pippin. Are you Danny Pippin?
Sir.
Good morning.
Good morning.
You're here in 25 CR 0017. Mr. Pippin, were you born in 1980?
Sir.
Last four digits, social security number 8968. We're here on a pretrial conference.
His is one of the cases we weren't able to meet on, so if we can have one more negotiation.
Negotiation day on July the 25th here at 9 AM. And the next court date is July 31st, 9 AM. Both of them are conditioned to your bond, Mr. Pippin. Okay? Jamie Scott. Commonwealth versus Jamie Scott, 25 CR 0018. Are you Jamie Scott? Born in 1985. Last four digits, social security number 9033.
Yes.
You're here for a pretrial conference.
Signing on her, on Miss Scott, if we can have one more negotiation.
July the 25th at 9 AM for negotiation here. Next court date, July 31st, okay? Clay Smith.
That is a notice to forfeit, Your Honor. It's a, I'm gonna ask them forfeit $1,120 that was seized at the time.
No
of the arrest.
objection was filed, no response, forfeiture. Andre Staten.
But you can also let Kelly know your birthday file from that.
He's where I didn't hear.
He's in the hospital in Clinton County.
Okay.
Okay, you wanted, he hasn't been arraigned yet, but we can go ahead and set a negotiation day for July the 25th. And he'll have a public defender. And so July 31st, so you need to make arrangements to see if you can visit him, call him if he's still hospitalized.
The number is in hospital.
Clinton County is what they tell me. Now, I had received a call on him from when they took him into custody. Is that right, Mr. Jailer?
Yeah.
That he had severe problems up here, and I guess they admitted him over there, right?
When there's no need for it.
Yeah, he was a witness in the case not long ago. I know he's got help.
Yeah.
Yeah.
Okay, so you go over there and we'll do those two negotiation days. Candace Staten. Commonwealth versus Candace Staten, 25 CR 0041. You are Candace Staten. Good morning. Born in 1983. Last four digits, social security number 2643. And you're gonna have to say something here. It's a voice activated thing. Okay? I want you, the public advocate, gonna represent you in this case, or you have a private attorney. Yeah, well, you don't need, I'm gonna go ahead and appoint a public advocate for the purpose of arraignment. And then give one of those forms for her to fill out, okay? Counselor, I'm gonna give you one of the forms for her to fill out, and you can do that later, have a meeting with her when we finish here. You have a right to remain silent. Okay, the grand jury of Cumberland County has charged you with complicity to traffic and controlled substance first degree methamphetamine. You understand what that charge is? Okay. You acknowledge the identity of your client, receive the indictment, waive formal reading arraignment, and if not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'm signing reciprocal discovery order, Ms. State, which requires the Commonwealth to provide you with information concerning your charges. You're scheduled for a negotiation day on July the 28th, and the next court date's July the 25th, rather, July 25th. It's negotiation day here, and the next court date's July 31st. You continue on your same bond.
Thank you.
Elizabeth Watson. Is it two? Are you Elizabeth Watson?
Yes, sir.
This is 24 CR 0086. Ms. Watson, were you born in 1970? Last four digits of your social security number are 8925.
Yes.
There's a motion to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person named in indictment number 24 CR 0086?
Yes.
Is your judgment impaired today? What? Have you discussed these charges with your attorney? Are you satisfied with the advice of your attorney?
Yes.
When you view the evidence the Commonwealth has against you, you believe you are fully informed about your case. You understand that you do not have to enter a guilty plea. You have certain rights under the Kentucky United States Constitution. I'm going to go over those rights with you. At the end, I'm going to ask you if you understand them, okay? You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial of a jury, the right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to receive evidence, call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. You have a right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charge. You understand about entering a guilty plea today, you give up those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I'll wait the pre-sentence investigation from the probation parole. In the event that I do not accept Commonwealth's recommendation after having reviewed that report, I will inform you that I'm going to sentence you to more severe or harsher punishment. You have a right to withdraw your plea. You understand that? Ms. Gordon Anderson, what's the Commonwealth's recommendation?
Upon a plea of guilty to possession of a controlled substance, first degree, second offense, the defendant shall receive a sentence of 3 years, probated for 5 years, supervised. The defendant shall be referred to the social service clinician. The defendant shall receive credit for time served, and the defendant agrees to have any and all contraband and controlled substances disposed of in accordance with the laws of the Commonwealth and the holding agency.
What's the fine recommended? Is that your understanding of the Commonwealth's recommendation?
Sir.
Are you pleading guilty to the charge because you did commit the acts charged in the indictment?
Yes.
Are you doing so of your own free will? The constitutional rights, it's still your desire to give up those rights and allow the court to fix your punishment within an range permitted by law. Okay, you understand after any its guilty plea, future convictions could be enhanced as far as range of penalty. Okay, is that your signature on the document?
It was, yes.
You have the document in front of you?
Judge, I got to look at it.
I need her to look at it on the record.
It's $200.
Okay, well, yeah. Okay, we'll have a pre-sentence investigation report done, and you'll come back here on July 31st for sentencing, okay?
Yes, sir.
Thank you. Cody Willis. Commonwealth of Kentucky versus Cody Willis, 25 CR 0040. Are you Cody Willis?
Yes, sir.
You were born in 1989?
Yeah.
Last four digits, social security number 2394.
Yeah.
You have an attorney?
No.
It's a direct spend.
You what?
It's a direct spend.
Can you afford an attorney? Okay, you give him an affidavit to fill out. I'm gonna appoint public advocate for the purpose of arraignment, okay? You have a right to remain silent. Counselor, do you acknowledge the identity of your client?
Yes, Your
The
Honor.
grand jury of Cumberland County has returned an indictment charging you with trafficking in the controlled substance, first degree, first offense. Mr. Bailiff? Counselor, you acknowledge the identity of your client previously, you acknowledge receipt of that with wait formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, Your Honor.
Okay, I'm signing a reciprocal discovery order here. Requires Commonwealth to provide your attorney with evidence necessary to provide you with a defense. I schedule you for July the 25th for negotiation day and July 31st. Those are the next 2 court days. Both of them are conditioned to the bond. Understand?
And Your Honor, he actually wants to ask the court of adjusting his bond slightly.
On my current.
Go ahead and take that form over there.
I work in a treatment facility and part of that is after hours, I go and do step work and stuff with clients at different places.
What are you charged with now?
It's a trafficking case, but it's an older case, Your Honor, so this predates anything that he had before. We called about Mr. Willis. He's doing very well with treatment. He's a peer support, plus he's cooking.
Okay, well, I'll change the condition of the bond and allow you to go to that treatment facility and do any work that you need to do, okay? Okay, did you get that change? Okay, Susie Willis. Commonwealth versus Susie Willis, 25 CR 0043. Miss Willis, were you born in 1963?
Yes.
Last 4 digits, social security number 3794.
Yes.
Okay. I'm gonna appoint the public advocate. Did you go to district court? Public advocate represents you down there?
Yes.
I'll continue that appointment. You have the right to remain silent. Grand jury of Cumberland County has returned an indictment charging you with possession of controlled substance, methamphetamine, possession of drug paraphernalia, failure to maintain insurance on motor vehicle, careless driving, obstructed vision or windshield, no expired plates, no registration plates, and no registration receipt. You understand what those charges are? You acknowledge the identity of your client, counselor, receiving that by way of formal reading arraignment, enter plea got not guilty, reserving all pre-trial motion.
Yes,
To
Judge.
sign a reciprocal discovery order here requires the Commonwealth to provide information to help you prepare for your defense. You get here at 9 a.m. on July 25th for a negotiation day in July 31st. You'll be here for a pretrial, okay?
Yes, sir.
Continue on the same bond. Tyler Wright. Commonwealth versus Tyler Wright. 25 CR 0035. You here for the purpose of arraignment. Be represented by Mr. Cross. The grand jury of Cumberland County returned an indictment charging you with possession of controlled substance, first degree methamphetamine, possession of drug paraphernalia. Mr. Cross, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pre-trial motions.
Yes, sure.
Okay, we'll be here on July the 25th for a negotiation day in July 31st.
Your Honor, we do have a motion on the misdemeanor paraphernalia. I believe we attached the docket entry from 11/13/24 where that case was dismissed in Cumberland District Court, which would be a dismissal with prejudice. So we could get that one.
I'll wait till y'all go through the negotiation. I'll consider that motion.
Thank you.
Okay. Thanks. Okay, is it anybody else here in the courtroom? I've got,
We need to go back to her. Physical jury.
okay. Howell versus Crystal Gerald's. 25 CR 002 and 25 CR 0034. Ms. Gerald's has previously been identified. What do we have here? It's a new lawyer in town.
I know, I don't know what I'm doing. I need to get Mr. Anderson back up here. It's diversion now.
Oh, I'm talking about this lawyer over here.
Oh, that guy. Oh, I thought you were talking about that.
Ms. Anderson, Is she gonna handle it or you gonna handle it?
I can.
Okay.
Give her
A motion to enter says you wish to enter guilty. Is that correct?
Yes,
Are
sir.
you currently under the influence of drugs or alcohol? Is this plea freely voluntarily given?
Yes, sir.
Are you the same person named in the indictment that we just read off?
Yes, sir.
Is your judgment prepared today in any way?
No.
Discuss the charges of the attorney, are you satisfied with his advice?
Yes.
Have you viewed the evidence Commonwealth has against you? You believe that you're fully informed about your case?
Yes.
You understand that you do not have to enter a guilty plea, that you have certain rights under the United States Constitution, or specifically, I need to know that you understand those.
Yes, sir.
You have a right not to testify against yourself, no one can make the same thing about the school trial of the jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses, called testify against you, right to accept evidence, right to call witnesses in favor. The right to appeal this matter at higher court if you lose. You have a right to private time, well, to prove without a reasonable doubt that you are guilty of charge against you. Understand that by entering guilty plea, that you give up all these rights.
Yes, sir.
Now, I may consider the Commonwealth's recommendation, but I may apply and range of sentence provided below. I don't have to accept the recommendation. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
Now, before I proceed with this, I've got to ask some qualifying questions. Have you been pretrial diverted in the last 5 years?
No.
Any felony convictions in the last 10 years?
No.
Are you present on probation?
No.
Do you understand if you successfully complete the diversion program, the cases will be dismissed pretrial diverted and have your record expunged? You understand that?
Yes, sir.
You understand if you do not successfully complete the diversion program, have a violation be brought back before the court. If I decide to revoke the pretrial diversion, I'll schedule a sentencing hearing. You'll be a convicted felon. That can be used against you in the future. You understand that?
Yes, sir.
Mr. Stockton, what is the Commonwealth's recommendation?
Your Honor, in 25 CR 2, she'll plead guilty of possession of controlled substance, first degree. 2 counts, receive a sentence of 3 years on each charge, to run concurrently for a total of 3 years. In 25 CR 34, she'll receive a sentence of 3 years on forgery, first degree. Those 2 sentences in each case shall run consecutively for a total of 6 years, pretrial diverted for 5 years. Diversion will be supervised. She'll get credit for all jail time and home incarceration she's previously done. However, she will serve an additional 90 days home incarceration, and she will be permitted to work while she's on home incarceration. She'll pay court costs at discretion of the court, be assessed by the SSC, follow all recommendations. She'll maintain gainful employment, and all evidence in this case will be destroyed.
What is court costs?
She has 2 cases. One case is 245, another case is 190.
I'll merge the costs into them. She didn't have a DUI or anything. So it'd be 245 total. I'll save you $195. Okay. Need some time to pay that. You pay it, that first payment 30 days from today. Okay, $30 every month, 30 days from today. That is your signature on the document there.
Yes, sir.
Was this gonna be supervised?
Yes, Your Honor.
Okay, you'll need to meet with the probation and parole officer there. Thank you. Okay, let's go to the Adair County Jail. Adair County Jail. See. Adair County Jail will have.
Yes, sir, we're on.
Scott Barlow, please.
I'm sorry?
Scott Barlow.
On his way, sir.
Are you Scott Barlow?
Yes, Your Honor.
You're on 25 CR 0016 for sentencing. Have you had an opportunity to look at the pre-sentence investigation,
Christie, we're on.
probation and parole?
Yes, Your Honor.
It's substantially correct.
Yes.
Counsel, is there any reason why your client should not be sentenced today?
No, Your Honor.
On a plea of guilty to theft unlawful taking over $10,000, defendant shall receive a sentence of 10 years to serve. And I will waive the court costs. Consider that. So was there a restitution order in this? No.
No.
Mr. Stockton?
There probably should be one submitted. If he doesn't want to agree to restitution, we probably need to have the hearing that Henry told him to get a plea. For 10 years, I didn't handle this case. Mr. Huntley did. I believe it was set for trial. And I know there was substantial restitution owed the victim.
Well, let's schedule a hearing on the 31st for restitution, because that could very well consider any motion for, affect any motion for shock probation that I have, to see if there's a restitution order in, and that restitution order would consider, Mr. Stockton, the restitution order would consider holding the probation until the restitution is paid in full. That would be a good agreement for everybody, give this gentleman an opportunity to work his way out of this thing. Okay? Thank you very much. Your attorney will be up to talk to you, okay?
I'll come see you.
William Burton.
Burton.
Are you William Burton?
Yes, sir.
22 CR 0059. Mr. Burton, were you born in 1996?
Yes, sir.
4-digit social security number 2964, is that correct?
Yes, sir.
I'm from shock probation.
Yes, Your Honor, with the subsequent charge that caused him to get revoked, Allen County has agreed to, or Warren County has agreed to sending him to drug court. And I just would ask that the court would go along with that.
What did he plead to here, Mr. Stockton?
He got a 10-year sentence on trafficking with a PFO, I think. And, he's got an extensive criminal.
I don't see how he's eligible for drug court anywhere with a PFO in it.
I guess I just need some kind of proof that he's in there. I'd want to agree.
I don't understand that.
I mean, I can get you any number if you need.
Have you been in contact with the drug court?
I have, Your Honor.
They sent paperwork. They sent it down the day I got arrested. February 26th, I believe.
Well, we'll take a look at it when we put you back on the docket on July 31st, okay?
Okay, thank you.
Right, and you'll need to go down there and see him,
I
okay?
will, yes.
Your attorney will be in contact with you, Mr.
Thank you.
Jeremiah Fulton.
Phone.
Jeremiah Fulton. Are you Jeremiah Fulton?
Yes, sir.
Okay, this is 25 CR 0015. Mr. Fulton, were you born in 2006?
Yes, sir.
4 digits of your social security number 1424.
Yes, sir.
And we're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report of probation and parole?
Yes, sir.
Substantially correct.
Yes, sir.
Any reason this gentleman should not be sentenced today?
No, Your Honor.
On a plea of guilty to theft and unlawful taking over $1,000, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. Defendant shall pay restitution of $1,625, or $50 per month. First payment due 30 days after the entry of the judgment until paid in full, jointly and severally by the co-defendant Eric Crabtree. What are the court costs in this case?
Court cost is $220.
$220, and you got the $50 a month restitution, right?
Yes.
And I'll let you pay another $30 a month for your court costs until they pay in full. The first payment is not due until 30 days after you are released. Okay. Thank you very much.
So, thank you.
Joshua Norris.
North.
Joshua Norris. Commonwealth versus Joshua Norris, 24 CR 0074. You are Joshua Norris, born in 1989, is that correct? And last 4 digits, social security number 9019, probation revocation. What does the Commonwealth have to say?
Your Honor, he's got a 15-year sentence on theft and endangerment. He's got a new felony assault case and a misdemeanor assault in Adair County. Mr. Rutherford said he wants a hearing. We didn't find out about this till last few days, and there's no officer involved in this, so we're gonna have to subpoena the alleged victims in this case for the hearing.
Right.
I think his father and another person at a wedding party.
Knife cut there.
Yeah, so if he wants a hearing, we'll have to get subpoenaed for that.
He does want a hearing.
July 31st. July 31st. 10 a.m. or soon thereafter, council may be heard. Okay, William Owsley. William Owsley. Commonwealth versus William Owsley. 24 CR 0010. You are William Owsley,
Yes, Judge.
1993.
Yes, Judge.
Last four digits, social security number 4996. What does the Commonwealth have to say on this?
Your Honor, this was on a diversion and revocation. He has been accepted into the specialty court program, so I'll be willing to release him whenever the orientation date is.
What was the underlying charge?
It was a possession case and he had some violations of drug charges. Drug tests, I'm sorry.
Okay, well, I will, as soon as the orientation is ready, been voted in, orientation, we'll release him on the morning of the orientation. So you'll provide me an order when that happens, okay? Thank you. Jennifer Robinson. Sentencing. Jennifer Robinson, are you our Jennifer Robinson?
Yes, sir.
24 CR 0041. You're here today for sentencing. You were born in 1986, is that correct?
Yes, sir.
4 digit social security number 0286.
Yes, sir.
You look at the pre-sentence investigation report done by probation and parole.
Yes, sir.
Is it substantially correct?
Yes, sir.
Or is there any reason why this lady should not be sentenced today?
No, Your Honor.
Okay, or plead guilty to burglary first degree shall receive a sentence of 10 years, serve 180 days probated. Or plea of possession of handgun by convicted felon. Sentence of 10 years. Tell me about the handgun again.
This is the case that we was gonna clean up the paperwork. Did we send you that?
No, I haven't received it.
Thought we sent you that yesterday.
Maybe, I'll be glad.
This is the case of the lady that, she had the charge pending and we extradited her from North Dakota. She got the year on the possession to serve. She about served out on that. And what started all this was that she stole a handgun from her brother's house. And that's this lady.
Can I say something?
Be very careful with what you say.
How do you know whether she's being careful or not?
I would advise against it, and maybe that's what I should say.
So that'd be another 180 days. She'd have about a total of a year to serve before she'd get out, and then she'd have another at least 6 months treatment. Which I definitely believe she needs treatment. A dual diagnosis center.
You understand what he's saying there, man?
No, not really.
Say it again.
She'll have to serve out on her 1 year sentence, which she's about ready to do, I would think, because it's July and she went in December of last year. In this case, she would have a 10-year sentence hanging over her head. She would have to serve an additional 180 days, then go to rehab for 6 months after she's out of custody. So she's going to be out of pocket basically a year and a half. And the underlying allegation is that she took a handgun from her brother and she's going to have 10 years hanging over her head. And it's not just rehab for drug abuse, it's also for mental health treatment.
And we have her at bed.
And Mr. Rutherford has her abated.
Well, it's gonna be a while before she's ready for the bed.
Yeah, they're aware.
All right, then I want to go ahead and I want to take all that and plead not guilty on all of it. Because the place that I burglarized, my dad passed away. That's my home now. It's on my driver's license. I didn't burglarize that place. And that is not a handgun. It's a 22 Remington rifle and it's at my brother's in his bedroom. My dad had removed it when he got sick before he found out I was getting out of North Dakota to come home when he was sick.
You'd have to file a motion to set aside the plea. She might have.
Well, let's do that. Yeah, let's do that then, because I'll go back through the whole trial again. I'll be fine with that.
I'm sentencing you on a plea of guilty, receive 10 years, serve 180 probate for 5 years, plea guilty possession of a handgun by convicted felon shall receive 10 years, serve 180 probate for 5 years. That should run concurrently for a total of 10 years, serve 180 days for the 5-year sentence shall run consecutive to come in circuit case 24 CR 0081. I'm waiving the court costs. Now, now you can talk to your attorney before you want to file a motion to set aside your plea or not, okay? Thank you very much.
Hey, I don't want him as an attorney. I'll represent myself.
Get this lady out of there, please.
Go on.
Let's- Yeah. What did you say, ma'am? Bring her back over here. You want to say something to me?
Sir.
Did you say?
Yes, sir.
Did you
Yes,
say-
I think it would be better because I know about the case and stuff. I think it'd be better if I just represent myself.
No, you can file a motion to do that, okay? You can
Yeah.
file- Thank you very much.
Yeah, thank.
Johnny C.
Yes, sir.
Commonwealth versus Johnny C.
Okay, right here.
Somebody needs to turn the camera on the seat.
It won't let me. I'm trying to, but it says the host won't let you.
Well, the host, will you let us see Johnny C?
Okay, got it now.
There you go, Johnny. Yeah. Your star again, Johnny.
Yes, yes, sir. I'm sorry.
Star 0067. Commonwealth Kentucky versus Johnny C. Mr. C, you were born in 1959.
Yes, sir.
Life for you, Social Security 8001. The motion, John.
Sir, yes, sir.
Yes, Your Honor, he was revoked after he had went to a long-term rehab facility, and after just 4 days, he left. He then tested positive. Now that he's been incarcerated, he's in a much better state of mind, and he's wanting to go to long-term rehab and get his life straight.
If he'll go, after he went for the 4 days and tested positive, he went to the jail. Mr. Garner went down there, offered him long-term treatment again. Basically, he told Mr. Garner it shouldn't matter what I put in my body, that I don't want to go. But if he'll go, I'll go along.
He's willing to go.
Okay, well, what you got lined up for Johnny?
I can get something in the next few days.
Well, Johnny, I'll agree to let you, but you see, I'll agree to let you do a long-term treatment, okay?
Sir, yes, sir.
Here's the thing about it. I've been knowing you since my whole life.
Yes, sir.
You know, you're just about 6 years younger than me. I've known you the whole life. You got a little stubborn streak in you, Johnny.
Sir, yes, sir.
You know it and I know it. Now you're gonna have to comply here for a little while to go this long-term treatment thing so you can get your freedom back.
Yes, sir.
Okay, I'll sign the order. Good luck to you. Okay?
Yes, sir. Thank you, sir.
Dennis Spears. Commonwealth versus Dennis Spears, 24 CI 0088. It's a motion to forfeit. Is that correct?
I really know.
Motion to forfeit.
It is, Your Honor. It's various personal items and evidence. If he's no responsible for, if
You don't have any objection to that, do you, Mr. Spears?
there's anything he wants back.
Is there anything they took from you want back?
I just want my wallet and my phone.
A wallet and a phone.
Let me see what.
It's up here in the jail, for sure.
Well, we'll check.
Yeah, I'm not asking for, this is just basically stuff that was seized at the night of the assault, like clothes that they took into evidence, a hunting knife, razor, blood swab, sweatshirt, and buccal swabs. We're not asking for
So
dollars.
your other stuff's up there at the jail's not involved in this, okay?
Okay, I didn't know.
Okay, no problem. We'll go ahead and enter the order and it won't, those things yet, the phone and wallet won't be in there, okay?
All right, thank you.
Yeah. Paulette Wilson.
You're good. Go ahead.
Commonwealth versus Paulette Wilson, 24 CR 0019. Are you Paulette Wilson?
Yes, sir.
Born in 1974.
Yes,
Last 4 digits, social security number 5611.
yes.
Here on 24 CR 0019 for a probation revocation. Mr. Stockton, what do you have?
We had this came up last month, Your Honor. She had left a rehabilitation facility early and tested positive for meth when she returned to the office. And she asked for the specialty court program. So she has been assessed. She's eligible and accepted if the court wants to release her to that.
I'm gonna let you go to the, what we call the drug court, see if you can turn your life around and make it, earn your freedom, okay?
Okay, thank you.
We're gonna do an orientation for you. And as soon as they do the orientation, I'll let you out to come here. As soon as they set up the orientation, I'll let you out that day. Probably give you time to go home and clean up a little bit before you come in for that and come in and do the orientation, okay?
Okay, thank you.
Adair County, do y'all have anybody else up there that we haven't seen that on your schedule?
No, sir. That was everybody.
Okay, well, thank you so much. Y'all may be excused.
Thanks, sir. Have a good day.
Does that complete the criminal docket? We will come back into session at 1 o'clock for the child support. What is that? What's the child? Got one show cause case here.
He's been paying every month. He's behind us.
Who is it?
Joseph Maxine.
Send him a show cause that they can purge himself by paying $100. The 31st of July. Okay? Good. Go off the record. Leslie Caffey, as parent and next friend of Aiden Bowles and Lena Bowles versus Brian Connor. Parties here.
Mr. Connor called the office. He didn't find out on Saturday, he was not busy.
Okay, well, we'll just pass over that till let's see if Miss Coleman shows up. Logan versus McCoy. Okay, what do we have here?
It's over custody, I agree, I believe.
Judge, I've been recently retained on this case and we will be filing a motion to modify time sharing by the next real day. I'm in the process of retaining an attorney. Due to financial constraints, it's been a little more difficult than I anticipated. I did bring with me a proposed parenting time agreement until we can get a modification through the court.
You talked to her?
Judge, I'll look at the modification. However, I believe last rule day you sent them back to kind of work out an agreement. I
Yeah,
believe that there are a few issues that will warrant a modification hearing. I'll be glad to
well, I
look
have
at
here,
it.
what are we gonna do before, who has the child now?
Mr. Logan has possession of the children. I have possession of the children. Okay, during the week. I think that that's a new developing
So is
issue.
there something that will continue for a while until we're not here again until July 31st?
The original agreement was when the summer break comes, she gets them through the week, I get them the weekends. During school season, I get them through the week, she gets them to the weekend. So.
Can that continue to July 31st?
Yes, of course. This was mostly about transportation.
Well, I don't want to get into the detail. I'm just asking you if the present situation can continue to July 31st. Is that right?
Yes, sir, absolutely.
Okay, well, I'll reschedule any motions you have for July 31st.
Thank you,
Okay?
Judge.
Thank you. Carver versus Carver. Hello. Yeah. We have a whole list of motions here, do we?
Judge, I've renoticed all my motions that I submitted back in May. I'd just like to request a hearing date on those motions.
What do you have today?
I don't have any motion drawn. I'm all here in response to Mr. Lamb's motion.
Are you ready today for motions if I do it at the end of the docket?
We could take up, I think, one or two of them. I think that there are some that are substantial enough that we probably would need to hear a date.
Well, let's go down through them. Let's click them off here just for a second. I read them last night, some of them I think here.
Judge, the motion to compel is on the basis of the physical titles to the assets that.
Are you talking about the motion on the discovery motion on have personal access to and whether or not some of the information was released to someone? Is there a motion about that? Or?
There is a motion for contempt there, yes.
Okay.
Mrs. Carver conducted an interview with the television news station where she revealed information from the discovery
wait,
file. That was subject
let's
to
go down
contempt.
through them here, the ones that I have here. This one says, this is a motion that you have.
I don't have any motions, Your Honor. We had a motion to compel that was heard in May. Your Honor entered an order on that already. That's been resolved.
It was here again.
There is a motion to compel that's filed by Mr. Lanham's client, by Mr. Lanham on behalf of Mr. Carver. But it's obviously a different issue.
What about some phone calls? Is there,
There's a motion about telephonic.
how many motions do you have? Tell me.
I have 6 motions today. Again, I know it's a lot.
Well, let's just go down through them, just mention, your first motion is about what? I've read all of them, but I can't, really, they're very confusing to me. You know, there's so many of them. What's your first motion?
There's a motion to compel.
To compel what?
the documents that Mrs. Carver has in her possession that
Yeah, so he
are,
can file his tax returns. That's the one you're talking about.
there's
So he
financial
hadn't filed any
information.
tax returns in
and the
3
physical-
years. Is
And
that
the
right?
physical titles, yes, and the physical titles of the assets that have been proposed to auction.
What do you have to say about that?
Your Honor, we've already told them for about a year and a half now, we don't have any more finals. We don't have the information. It was not formally requested, but that's okay. They sent a letter. They also asked for them at the depositions. I told Mr. George that. I told Mr. Lamb that. And this idea that he hasn't filed taxes for 3 years because she's not cooperating.
I didn't understand that. I don't understand it. What do you need from her to file taxes?
But my understanding is that as part of the USDA's FSA program, back during COVID, the parties had received a pretty substantial amount of money from the federal government. There are financial disclosures that are inside of that have to be compiled into the tax returns that you are going to file.
What does she have that he needs to do these financial disclosures?
When the parties separated, Mrs. Carver took every piece of paper that was in the house.
Birth certificate, social security cards, everything.
Okay, well, what if she says she doesn't have? That's what you're saying now. She doesn't have.
I think she has social security cards. He
But
doesn't.
how
he
does
knows
that
about
have, what does that
taxes.
have to do with the tax returns or these USDA disclosure things? What allegedly, step away from the podium. I don't want him to, for him to tell you privately. You tell your attorney privately. I don't want you to have to come out and blurt it out. What is there that she has that you gotta have to comply with the USDA things?
There's documentary evidence that the relief funds were spent on specific farm payments. And that's the documentary
Would
evidence.
they be
that-
checks or would they be,
I believe they would be checks.
Well, I mean, you can go get copies of checks from banking institutions. If she says she doesn't have copies of the checks, then you can, what if their house had burned? You can go back and get copies of those. I don't, if she says she doesn't have them.
I believe there are additional invoices and handwritten documents that are.
She says she
included.
doesn't have them. Well, I mean, he says she does. I don't know how I can overcome that. She doesn't have them. Maybe he needs to go back where these invoices were created or whoever he bought them from and recreated. So I don't think we can resolve that. I'll put her under oath if you'd like me to, and she can say that she doesn't have them. But I don't think it'll accomplish anything. Now, what's the next motion you got?
We have a motion to modify timeshare. That's essentially the same motion that we put on back in the fall. That was supposed to be part of our hearing back in December, but we ran out of time. The motion to reduce the child support, I think, was intended to be incorporated into that hearing, but again, we ran out of time. I think we will need to put on some evidence for
And what
that.
else you got?
We've got several
Timeshare,
motions, for-
child support, what else you got?
motions for contempt, the violation of the protective order.
Okay, well, what's the contempt motion would be violation of protective order on the interview she did about the criminal charges against him?
Yes. Where she referenced specific information that was, she only
Now,
would have had
it
access
wasn't
to
a real
in the
good
discovery
idea
file.
from your client.
She did, Your Honor. Point blank, full stop. She didn't give an interview, period.
Judge, the person on the recording is either Mrs. Carver or her sister.
The information on the recording in the news article cites the civil case he's a defendant in, verbatim. The news article shows the complaint that Bluegrass Stockyards filed against him, that he's, excuse me, Mr. Lanham, that he's defending. That's the accusations in the news article. It has nothing to do with the discovery file that has never left my, not just my firm, my individual office.
Okay, now, if the language that's used in that, do you have a copy of the interview?
It's a video.
You have a copy of it? the
I
video?
can get a copy of it, yes.
And so have you reduced the allegations or the statements in the video down to writing to compare them to what would be available to the public in the civil suit? Have you compared those two documents?
I have compared them. I've not transcribed them.
Well, I would like, before we do anything else on it, for you to
I
transcribe
can
them
do
and
that.
compare them and see if it goes beyond the information that's contained in that civil suit. Okay,
I can do that.
okay, now what's the next thing? Yeah.
The agreed order, the existing order between the parties, requires reasonable telephonic contact. between Mr. Carver and their
You said there
child.
was 114 attempts and like 20-something connections, you said, right?
That's correct.
Okay, what do you have to say about that?
Your Honor, I think you'll have to hear proof on that. You're gonna have to hear from the parties. She has provided me, I'll tell the court, very extensive chronology of phone calls, offers to Mr. Carver, attempts to say, I'm gonna be here with the child, or I can't. I mean, I can't summarize that.
What we're gonna have to do is obviously these parties are not going, what we need to do is get a structure of set times for phone calls. They're not gonna agree on anything. They're not gonna, both of them are gonna have police adverse here, so. I want y'all to work together to set a certain schedule. She shall have the children available, he shall, when he's got them, they'll be available on a time certain. Not gonna be any contacts or attempts to contact each other unless there's an emergency, okay? Now, what's the next thing you got?
At the end of our hearing, you had admonished parties to make sure that there was reasonable contact between the child and Mr. Carver's parents. And that has not happened. There's been no effort whatsoever to make sure that that happens.
What's the story there?
That's, again, I've got specific dates and times where he's offered time to the stepmother, or excuse me, mother-in-law. If the motion sets out dates that they claim the child should have been made available. Well, first of all, the order doesn't require it, but Your Honor clearly encouraged it, and I acknowledge that. She's gone through these dates and provided, which she could present proof that the child was not in school and she wasn't at work for various reasons, like MLK Day.
Your motion said that instead of letting the grandmother have visitation, she'd take the child to work with her and that sort of thing. That's what your motion
That's correct.
said.
At this point, my understanding is that Mrs. Carver has hired a caretaker to be with the child while she's at work right now during the summer.
That may be partially true, Your Honor. Now, that wasn't in the motion. I've not talked to her about that.
See if y'all can agree to some set grandparent visitation thing. So this lady won't be called upon to make decisions and back and forth. I remember this from the testimony that the special involvement because of the special situation with the child that the grandmother had at one time, see if you can work something out as far as set visitation with the grandparent. What else you do?
I think that's it, Judge.
Okay, well, y'all have I think that we need the two of you, if you can, if you've got time to do it today, to sit down there and give me a set of issues that need to be resolved before I go on and have a hearing that will seem like forever and not get me the things that I have to decide. So you get me some decision points, for lack of a better word, some decision points that you disagree on that I need to make a determination on. Because I want to pull this down to something I can get my arms around.
Yes, sir.
Having a hard time getting my arms around it right now.
Understand that.
Okay, well, thank y'all very much. And
Judge.
yeah,
I hate to interrupt. There's another issue that arose within the last couple of days where there's non-marital property in the form of tractors that Mr. Carver has had situated in specific places. And Mrs. Carver has enlisted the assistance of some third parties to relocate that
I'm not
non-marital
understanding
property.
what you're saying. Y'all, he has some tractors and she sent somebody to get them or something?
Yes.
Is that what you're saying?
They're not marital property.
Well, that's disputed.
Whether it's marital property.
Correct.
Tell me about the
Number
tractor.
two, she has garnered some of the assets because the assets have been, I'll use the term disappearing, number one. Number two, I've been contacted by two banks that are trying to sell their assets that he has started. He's done that unilaterally. So we were here in May, Your Honor, not the
The banks are owed money and they want
by
to.
him, and they're not collateralized, but he's offering to sell things and have the bank come pick things up and sell them.
Okay, well, I'm gonna tell you what. Nobody's selling anything. I want to order freezing all the assets. Nobody transfer any assets or anything. What are you doing? What are these expressions you got going on here?
Me, sir?
Yeah, you.
Well, I mean, with the tractors, for example, I mean, I was told when we started this not to move anything. But the part about me selling stuff is why I'm not done it.
Okay, then you should be concerned about this.
The only
Just
thing-
don't say anything else. If you're not trying to sell assets, don't worry about it. Nobody's selling assets. We need to advance this case forward. And if we need, I want you to get all unresolved issues down and we're going to dedicate an entire day to solve all this, and we won't have to wait forever to do it. Yeah. 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 Yeah, y'all have your calendars with you?
Yes, sir. And could I make one point to the court that I
Sure.
want you to be aware of?
Sure.
The hearing in May was another order that you entered requiring Mr. Carver to file meaningful disclosures in the case. And the reason I bring that up, it's impossible for me to try the property aspect of this case until he's done that.
Yeah, and he hasn't done that yet.
That's been admitted by his counsel. At his deposition, they admitted that. That was a year ago.
Well, you know, I really didn't ever have any really great expectations that we were going to get a good inventory of anything. I never had that. Considering the other problems that Mr. Carver has, I think his filing income taxes are going to be very difficult. You know, because I sit on the criminal portions of it too. If you have entered pleas to criminal activity where you have absconded with this money, you also have a tax problem. You know, I don't know the answer to that. That's a rhetorical question. I mean, I understand the
Well, I mean,
complicated
for the record, there
situation.
was no entry of a plea. That's,
I say if you do, I say it's a hypothetical question. I hadn't suggested he has, okay? But if you have these accusations laying out there, this money has changed hands or this money's been expropriated. I mean, it makes it difficult with that hanging over you to make any kind of disclosures of things. I don't know. It just seems like the hole keeps getting deeper in this case all the time.
I would like to set this, the order you entered in May gave them until, you entered it June 4th, they gave you 30 days. So that's gonna be sometime next week to do that. And I'm sure we're not gonna set it before then, but I hope Mr. Carver does his best to comply with that order so that this date we set will be meaningful.
Well, I don't want to set a date unless we find out. I do know the previous, there are new charges against him, and you're representing him in that. I won't rehash that. But the previous charges that were made against him, there was a considerable cash settlement made on those things that I'm aware of when the thing was dismissed. So, you know, that's what I was kind of alluding to, you know, I mean, if maybe there was no admission in that agreement, I wasn't privy to that agreement. Maybe there was no admission, it could be but it's a complicated financial situation, I'm sure, with all these other federal funds and stuff. What kind of, you need to, with specificity again, although it might be repetitious of what you've done before, tell them what you need from them.
Yes, sir.
Okay. If council will serve on you again, a list of things, because I know you came into the case midstream. There were previous counsel there. Maybe there's something that you think you're going to share that hasn't been shared. But I want a particular list of things that you want Mr. Carver to provide as far as discovery is concerned. Now, we got our calendars out here. I would suggest that this is the sort of thing we can do on a Wednesday, even when district court is going on, and we can use the downstairs court. It's not a lot of things we can do. Is July the 9th too soon?
I believe so, Judge.
Too soon. Okay, well, I've got something that we just scheduled today on the 16th. I'm not going to be back on the 30th would probably be the first day. That would be July 30th. Would that be okay for both?
I won't be available that day, Your Honor.
Okay. About August the 6th.
Got a hearing in Warren County that day.
Okay. Let's go back. Forget Wednesdays then. Let's go back to some other day. What about July the 18th? Is that too soon? Friday.
And Judge, I think we'd be best served to try to look in August and
Okay, well, let's go to August then.
if this is a final, yeah, if this is a final trial, then both parties will need to file those final disclosures 14 days before that final trial. It looks to me, Your Honor, the week of the 18th would be pretty open for me. Couple things, but I could move anything really that I have that week.
That's the week of the prosecutors conference. We don't have a rule day that week.
I'm not available that Friday, but I can work it today.
Okay. What about the 15th?
Actually, I have a jury trial in Warren County the last half.
Y'all too busy to handle this case. Let's see here. What about the 21st?
Of August, I'm available.
Time as well.
August 21st. That one. And it'll be the final trial. Y'all make any disclosures that you need to make, and that way, anything that you haven't, that you're.
What time would you like to start that day, Your Honor?
9. Because I figure we'll be here for a while.
So disclosures by the 7th, that'll be 2 weeks.
Disclosure by the 7th. Okay. Is there anything temporarily that needs to be done?
I don't think so, Judge. I know Mr. Carver, he wants to change his time schedule, but given the fact that final trial now is less than 2 months off.
What does he want to change?
Given that it's the summer, he's got free time, child has free time, he's not at school. If there's any additional time share that he could have without a hearing, I think that would be appropriate.
What, give me some specificity, what you got in mind?
Right now, the child's with Mr. Carver from 2:30, I think until 6 o'clock on Tuesdays and Thursdays.
Yeah.
If that time frame could either be extended or have another day of the week, I think that'd be appropriate. As of now, there's no vacation schedule of any kind in terms of the time
No.
share.
Why don't we move it on those days? He already has it from 2:30 to take it from 10, start 10 that morning. 10 that morning all the way through, okay? And yeah, that's not a lot, but it's enough to let him go somewhere, take the child somewhere and do some kind of function, okay? Okay,
Thank you, Judge.
okay. You need to make, and I'd like to make an effort to do some grandparent agreement before y'all leave today.
Yes, sir.
okay?
We'll have that discussion.
Okay, thank y'all very much. Okay. Kohler versus Kohler.
That's it.
Hello.
I think my partner's on Zoom. I think, the petitioner's attorney's on Zoom as well.
Yes, Your Honor, I'm on Zoom. Thank you for letting me appear on Zoom. I'm over in Jefferson County, so I think y'all are about 2 hours away from us.
I have very little sympathy for anybody being 2 hours. We're 2 hours away from everything, so.
That's fair.
Okay, what do we have here?
Just a simple motion for order of sale of jointly owned real estate in a divorce case. It's there's no mortgage against the property. It's the only piece of real estate that they own. The party, brief history, the parties separated in North Carolina about 4 or 5 years ago. And they sold their house there, and they each received about $370,000 each as a result of that sale. They divided that money, went their separate ways. Mr. Kohler moved to here in Birchmont, bought this house, and the parties reunited briefly. And then my client left and withdrew her money. that she brought into it back, her $370,000. And Mr. Culler's now claiming that that she owes him part of that money back, that he doesn't have as much money now. And what he's done is he's put money into this house, and we dispute the amount that they've appraised it for, and we just want it sold. Because Mrs. Culver had to leave the home due to domestic violence.
Okay, well, so, what do you have to say, Councilman?
Your Honor, I think this is really premature. We've got mediation scheduled August 28th. I don't believe we've really divided any sort of assets, which we're hoping to take care of at our mediation in August. This is also the first that I've ever heard that they're disputing the appraisal. I mean, the house was appraised at the end of 2024, and opposing counsel, he was provided that appraisal, and this is, like I said, the first I've heard that they do not believe in the appraisal.
Briefly, Your Honor, this is their biggest asset. She believes it's worth about $350,000, and they've got it appraised at about 250 or 60. And I don't see.
279,000.
And all I want to do is.
You need to speak up just a little bit if you could.
Prior to mediation, Your Honor, where we're going in with all these liquid assets, this is the disputed item, and once it's liquidated, like everything else is, then we'll be able to successfully mediate the case.
Your client resides on it now?
No, my client had to leave due to domestic violence and left
Okay,
the
and does
state.
she reside on it?
No, she does not reside on it.
Okay, well, what's the problem with selling this then and holding the money?
My client currently lives in this house. He doesn't have the assets currently to purchase another house.
I thought you said no one lived in it.
No, my client lives in the house. This is my client's only house.
No.
My client doesn't live it. She had to leave.
Well, I
And she's been
understand that, but I
past-
thought you said, I thought I asked whether either one of them lived in it or not.
Well, I know he does. I
He lives-
misunderstood.
Well, I'm not gonna sell a house he lives in until this is over. Okay,
Okay.
now, then we probably need some kind of protective order on the phone. Is the house insured?
I'm sure it is.
Well,
Yeah. Yeah, I believe the house is insured. There's no mortgage on the house. It's really just
What's mediation set for this?
End of August.
August 28th.
Can you do it quicker than that?
But we set it out to clear up all items of discovery and so forth. So when we went to mediation, everything would be.
Who is the mediator you chose?
James Mattingly.
Yeah, Jimbo.
Yeah. Well, if you decide you can't reach a resolution, fortunately, we can get whatever you need to do done quickly here. Okay, so we'll be back here on August the 28th, and your mediation day was what?
August 28th is our mediation date.
Yeah.
It certainly happens to be our rule day, but that's unfortunate because if it had been earlier than that, you could report back here on August 28th to see if there were unresolved issues.
I tried to have it scheduled in June or even early August, but Mr. Bertram wanted it later in August.
Why don't you see if you can get Mr. Magley to do it a couple of weeks before that? Okay?
Okay.
I think that would, let's say if you could do it in mid-August, see if there's any resolution. If there's not, we can be back on the docket here on the 28th of August to see what unresolved issues we have that I might have to decide. Okay, does that sound fair?
Sounds fair to me. Good idea.
Okay, thank y'all very much for your patience.
Thank you, Your Honor.
Bank of America versus Hutz.
Please the court.
Yes.
Frank standing in for Lloyd McDaniel, counsel for plaintiff on this motion for summary judgment.
Is there anyone, no response been filed?
Your Honor, I haven't seen even our motion for summary judgment. I'm
Yeah,
here as
okay.
counsel, and usually I am supplied with a lot of documents electronically. That was not the case. this
Somebody
time.
check the file there and see who filed a response for the defendant.
I do assume our proof is filed.
The respondent filed a handwritten answer.
Yeah.
That was the original answer, Your
It
Honor.
wasn't me, I didn't do it. Is it?
I'm writing concerning the debt account, account number ball. I have been paying on both accounts since 2017 and never stopped paying. Someone on the end of Lloyd's office must have stopped payment. I'm willing to pay in both accounts. I'm on disability package since 2013. I'm not able to work actually. With my disability. My life doesn't work at this time either. She says someone helps me. There's only my income for social security, and if you list all this income.
And none of that constitutes a defense, Your Honor. We file our proof and judgment.
Yeah, last week, Mr. Hunley, like Mr. Stanley said, look, last week was a week for mercy. This week's the week for justice, right? Is this place we're gonna sell? Is this his home or is this a debt or what is this? Is it mortgage? I couldn't tell by the motion it was filed. What kind of loan was this? Do you know anything about it?
Again,
Okay,
usually
I
I
got
was supplied
you.
with
I
all
got
that.
you.
This time I was supplied nothing.
Okay.
I apologize.
We'll find out. Look at the complaint. I read the motion. I couldn't.
It looks like it's just for the judgment. It was a credit for judgment.
Credit card. For how much?
$10,907.28.
And they're asking how much now? Just that is what?
$10,907.26. That's including the attorney's fees and judgment.
Okay, I'll go ahead and sign the order.
Thank you, Your Honor. That's all I had.
You've done a great job here with what you had to work with. See, you leave a complete winner.
I had 12 in Harlan County this morning and had my head handed to me on 3 of them.
And in Harlan County? Well, you know, I tried a murder case up there, a couple murder cases. They got it. Who was sitting on the bench up there today?
Oh, goodness. That was Honorable Kent Hendrickson.
I know Kent. Yeah, sometimes they have other judges who come in. Well, I'm more, you tell Kent, if you can see me, I'm more pleasant to deal with than he is.
I will.
Okay. Okay, just take it easy, yeah. Day versus Kirk.
I received an email from Ms. Capps this morning that says, I've been in communication with Mr. Pennington this morning. He intends to file a motion to withdraw, plus I'm stuck in Somerset Communication. We'd like to pass this for review to July 31st.
Okay, the case of past, who represented you, Mr. Pennington? Yeah, well, you need to call Mr. Pennington. He's told counsel on the other side that he's gonna withdraw from the case, so you need to find out what he's doing, okay?
He got a job as
I don't know what he did. I'm just talking about his involvement with you. He's assistant county attorney in Clay County. He left here. So if you have any motions or anything that you want scheduled, you need to talk to him, see if you need to get another lawyer. Next time we're here is July 31st, okay?
Thank you.
Okay, thank you very much. Pruitt versus Curtis. Now, this is a motion to establish grandparent visitation. Is that what that is?
Yes, Your Honor.
And you represent
Ms. Pruitt.
Ms. Pruitt.
Yes, Josh.
What we got going on here?
Well, there's just not an agreement to it, Judge. I don't know how many of the facts are in dispute, but my client spent a significant amount of time with these grandchildren before her son, who was the biological father, was incarcerated this past fall. Now she's not saw him in 3 months.
I will tell you that I'm ignorant as far as the rights of grandparent visitation. I don't know anything about grandparent visitation. I remember there from time to time when I was in the legislature, is there statutes about grandparent visitation?
Yes, sir. 405 .021 addresses grandparents visitation, but it gives very limited
guidelines or even rules on.
Yeah,
it.
that's, I remember they always tried to flesh it out, but I didn't know whether it'd been fleshed out, because I don't know whether I've had another case since I've been on the bench here for nearly 13 years about it, so.
Judge, I would say that on the face of this case, I see an automatic problem. I don't see that a GAL or Mr.
Oh, yeah,
Smith has been
he's
served.
incarcerated.
I think he's filed
He's filed a written, saying that I was a Smith give consent to my judge and to proceed with court proceedings with grandparents visitation.
It really doesn't have him, I guess that could be an entry of appearance, I guess, I don't know. I think I probably ought to appoint him somebody anyway, just to do a cursory sort of thing. Who's next up on the list, clerk's office?
It's not. We might just have to look at it. I'll know exactly who's next on the list, but.
We'll appoint somebody, let's appoint him somebody, and then, what is the problem with some kind of limited visitation? Is it?
Judge, I think that Ms. Curtis is the fit and proper parent and would like for any type of visitation to be at her sole discretion.
Well, yeah, but she feels that she has just cause to
Absolutely,
object.
Judge.
We won't go into today because nobody's had time to prepare it. We don't have the guardian ad litem there. I guess if y'all will schedule, let me get somebody appointed right away, and y'all we need to redocket the stuff for July 31st. And if you could go back there and while all the lawyers are here and everything, and see if you can reach any resolution to the thing before we leave here.
Your Honor, if the court would, if we can not reach a resolution on this, I will be out of town July 31st.
Well, what's I don't know what to do. You can put it off till August 28th be the next time we have something.
I don't know if we could get a hearing date between
I
then.
don't know what there is to hear, first place, we gotta get somebody to interview him,
Yes, sir.
and then we'll see if you get any resolution, but till then, there's really, I don't have anything that says this. It says attending weekend visitation based on the schedule she had when supervising her son's visitation. So what, the son had visitation schedule and that stopped since he's incarcerated.
That's correct, Judge.
She's attempting to stand in his shoes. Is that right?
I mean, that would be ideal for her.
That would be her optimal position, is that she would exercise it.
Per the statute, it's a best interest of the child standard. And then you have to prove a significant and viable relationship. And there's 4 different ways to do that. So it'll have to be proved that either the child resided with the grandparent for 6 consecutive months. The grandparent was a caregiver on a regular basis for 6 consecutive months. The grandparent had frequent contact with the child within the last 12 consecutive months, or any other facts to establish that the loss of the relationship is likely to harm the child.
That fourth one is pretty broad, isn't it?
I think under the third prong is what we were proceeding with, Judge.
And under that prong, Judge, any visitation they had was sporadic. There was nothing court ordered for Mr. Smith. It
That'll
was
be
very
what the
little.
proof is about, if
Yes.
we get down to that, so. I don't know.
Mr. Poindexter's next on the list, Judge.
You what?
Mr. Poindexter's next on the list for GAL.
Okay. So we report Mr. Poindexter then. So, okay. And we'll, after that appointment takes place, then we'll look at in August, and if y'all can work out something between now and then to alleviate the necessity to do this thing, that's fine. And if you can't, your client has reasonable grounds to believe that that's not the child's best interest, then we'll go down through the prongs and make some findings, okay?
Thank you, John.
Okay, thank y'all very much. That's the end of the civil rights.
No, what's there on this? This only make it first.
Yeah. Okay, Clinton Circuit Court now, the versus Connor. Yeah. Where's the other side? Mr. Connor said he didn't have any notice of it, right?
He said he didn't find out till Saturday.
He didn't find out. I mean, I mailed him notice. Every day I said I did. I mean, Judge, he contacted my office yesterday. I know he was aware of it.
What was your motion to do today?
It's a motion to set
a
it.
trial?
Yeah, we just want a bench trial, Judge. I don't think there's any issues of fact. It should be pretty straightforward, so I think the court could address it very quickly.
Is he, he's not represented by counsel?
No.
Great. Great. What length of trial do you think you're gonna be dealing with here?
Judge, if it's a bench trial,
What are the issues?
it's fairly straightforward. Like I said, Mr. Connor has a life estate in a piece of property that Ms. Cappy's children are the remaindermen, and he employed someone to log the property without permission from the remaindermen. So, I mean, I'll have 3 witnesses, I guess. I don't know about Mr. Connor.
Has he stopped logging there already?
Well, the logging company stopped themselves when they became aware of this. So I did submit something asking for injunctive relief. I don't know if it was ever reviewed by the court, but I do know that the logging company stopped it. I don't know that that was the actions of Mr. Connor.
Okay, well. Well, let's just schedule we're gonna be over there on July 10th. At the end of our docket on July 10th, but you just said then if it's not gonna take
It's
us.
July 2nd, sir, motion.
I thought I had it July 10th. Was it originally on July 10th? So we moved it to the 2nd. Is that probably too soon, isn't it?
Well, I think Mr. Connor wouldn't even give it a week's notice.
To set the hearing, get here. Set the.
I'd rather just go ahead and set it for everybody. Let's do it on July 2nd. Remote notices for a motion set for trial on July 2nd.
Is that, I mean,
You can appear by Zoom if you want.
right, I guess I'm just saying it's obviously not gonna be adequate notice because we're 6 days from that, right? Am I doing my math right? It's 26th, right?
Well, he had adequate notice today.
Right.
So I'm just gonna suggest that we try it, and he comes up and brings up the fact that he doesn't have proper notice, and I'll address that issue. Now, all we do is set the date.
So that is just to set a date, is that what you're saying? Okay.
And then I can set a date very quickly. It won't be like a month out or anything.
Right. Okay.
But I don't really see setting a date without him being present, because he might have witnesses or something he needs to call. I don't know. And so you don't have to be there. You can appear by Zoom on that day, okay? Have your calendar ready.
I will do it.
Okay,
In
thank
Clinton
you.
County, do I get the Zoom link from the clerk's office or from you all? Clerk's office?
It'll be the week of, I would say that the week of the 2nd, but I'll send it to you on the 2nd.
You'll send it?
Yeah, I'll send it.
Okay.
Probably on the 1st.
Okay, very good. Thank you.
Okay. Now we have the Pulaski County case that's scheduled at 2:15, but we have jury orientation at 2:15, so I want to take that up now if we can. We have the new jury coming in at 2. So let's take it up now. Head versus Sloan and others. Good day.
Good afternoon, Your Honor. I am Jim Ridings.
Remember you, yeah.
I'm here on behalf of Karen Head. She's the plaintiff in this case. I'm going to be relatively brief today. You may recall that when we were here previously, you orally entered and made a docket entry of summary judgment in favor of the defendants and against my client.
Did.
And a notice of entry was sent out by the clerk. It was a notice of entry of the docket notation. I felt I had no choice under the civil rules but to file my motion to reconsider the motion to alter, amend, or vacate. I anticipated that the order that you had declared that Ms. Huff should prepare would be entered before today. It has not been done, and basically my point here is that I'm just making inquiry as to whether
Your time won't run until that's signed. You're worried about your time running?
hang on.
Okay, well, it will not run until she submits it to enter that judgment.
I didn't know that either, but I'll check. I thought it was in.
Have you submitted a judgment?
Yes.
Did I enter it?
No.
Okay,
It's probably an issue with e-filing since it's a class, circuit court case. I don't know that it.
did you e-file it down here or in Pulaski County?
We would have
e-filed it in Pulaski, also sent it to Ms. Thompson.
Okay, well, just give us a copy of it. Have you got a copy for him to review?
I have reviewed it, Your Honor. I've
Okay.
seen it.
Okay, we'll just review it. We'll take action on it and you enter an order, a protective order for yourself that your time will not start running until this is entered, okay?
That sounds great. So no
Okay.
argument today. on
That's right. It's not necessary. I think you would agree with that. Okay, thank y'all very much.
Thank you.
Yeah. Could y'all come